Yes. Ah. So how does it matter? Why? Huh? With the content of prisoner, I victim is item number 13 and 14, my lord. 39. 13 and 14, my lord. 13 and But the 14. content also has a person equally for today, my lord. Oh. Who is having? My lord. Mr. Kejriwal. No, who? No, my lord. He dared a newly engaged counsel. Who has taken? You have taken? Yes, my lord. Your name is? P. Das, my lord. I'm on behalf of B. Chaudhary, who is conducting this plan. Mr. P. Das, on behalf of Mr. P. Chaudhary, SC, APDC, please for a journey. On the ground of some personal difficulty. Praise the Lord. This is the matter after. And can it be on 10th of September? What? Okay. Yes. I prefer listing upon date petition. Date petition. All new. On 21st. Huh? 21st, your lord. 21 August. It's an old matter. Pending for it. 21st is what day? Just put the. I cannot see the calendar. 21st is. Okay. If you new or old? New or old? Is it a new matter, old matter? Huh? New. Yes. 1, 2, and 10. Huh? 1, 2, and 10 rated same. Out of three, only one. I got only one specific direct. Item number Item number 2. two. Specific direction. Item 2 is in the list. This. Others, Add serial number serial number 55, mine. 55. What about 1? Why is 1 not in the list? They supplied me bunch of documents regarding the two items, but there is no uh, clarification regarding. Huh? Bunches of documents supplied. No, bunch supplied to you. That is not for me. That is for you. The name is not there. The name is not there. Then you have to find out why it's not there. You see, you've got to comply with the order. If you don't comply with the order, then we'll have to take serious action against that person. Officer may clear it. Huh? Concern officer may clear it. Huh. 55. No, 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 it's not like that, Mr. Counsel. There are others who don't approach also, they should speak, they should get. The law of the land applies equally to everybody. Item number two. Yes.
C144. ₹14 lakhs.
Regarding this pending liability, principal secretary already issued speaking order. Concern of officer.
They are just writing letters, that's all. As if they're going to do something. They're not going to do anything. I doubt. You see, the money has already been given to you. You have given a letter of 1st August 24. I have got a letter of 9th August 24, which you have not given to me. Now this I got another case. Yesterday's case. Where, uh, yes, for 40,150 lakhs. That comes to how much? 40 crores. But that will come to 401 crores.
401 crore.
401 crores has been given. So you pay them out. What is it? They tell your officers to give you up-to-date instructions. Okay, item 2, you're right. Third, Mr. A. Boro, learned counsel for the petition. And Mr. P. Huh?
R.K. Musari.
R.K. Mushari, learned counsel for the respondent number 2 to 6. Mr. T. Sharma appears for fund. Then you take in this order dated 21/6/24, the first paragraph. Okay. Next paragraph, Mr. R.K. Mushahari submits that the petitioner's case has been considered by the PTC authority in terms of the decision of this court in Shamsher Ali was State of Assam and others, reported in 2008, 4GLT1. And that the petitioner's claim for rupees 14 lakh is found to be genuine. He has accordingly been put in serial number 55 of the list of what? List of
Pending liability.
list of persons against whom the BTC has pending liability. So the further, the petitioner would be paid as per his serial number from the SOPD fund to be allocated to the BTC from the government of Assam. Next para, Mr. T. Sharma, learned counsel for the respondent number 1, submits that 50% of the SOPD fund for budget allocation to the BTC for the financial year 24-25 has been given. Good stuff. I have got it here. Good stuff. I have heard the counsel for the party. The letter number BTC/F bracket court case 103/2022/160 dated 9/8/2024 issued by the Secretary BTC to the Senior Standing Council BTC is to the effect that the BTC has received 40150 lakhs from the government of Assam, which is 50% of the SOPD fund for budget allocation to BTC for the financial year 2024/2025, as first installment. The letter further states that in principle, it has been agreed that a target of maximum 10% of the total SOPD fund would be allotted by the BTC for paying the contractual dues of the BTC. Good, sir. Next, sir. In view of the stand of the respondent BTC that they are liable to pay 14 lakhs to the petitioner, and keeping in view the letter dated 9/8/2024 issued by the Secretary BTC, the respondents are directed pay to the petition the admitted amount of rupees 14 lakhs within a period of huh? Within a period of 2 months from the date of receipt of a certified copy of the sort. Huh? Not then we'll give them free ration somewhere. What is this? Not possible. When is it possible? 4 months. Why 4 months? Can I take it step one? No, I'll record his submission then 4 months. Mr. RK, Mr. RK Mushahari, no. With regard to the period for paying the admitted amount to the petitioner, Mr. RK Mushahari submits that. The 4 months time period may be given for payment of the same to the petitioner. So accordingly, the respondents are directed pay to the petitioner the admitted amount within 4 months from the date of receipt of a certified copy of the form. The writ petition is accordingly disposed of. And item 1. Huh? He has not prayed. They have prayed. Where have you prayed? Pending disposal. This pending in the interim you have prayed. No. Interim. That's it. Okay, that's disposed of. Now the next one.
One in 10. Concern officer will get.
Huh?
Concern officer. Maybe principal secretary or to prepare and speaking order 12 then second.
Look, the problem is actually there was an earlier order passed in 2022 in another writ petition. We have not complied with that order. But because of delay in approaching the court, he has filed a separate writ petition. This is the second time. I will call the secretary BTC. Right.
No,
No, I'll call the secretary BTC. Let him come.
CST, my lord.
No. I'll let the
The
secretary.
liability, as per this notification, the head of the department is liable.
Who is the head of the department?
Concerned department,
Who is the concerned department?
Kennard, CST, head of the department. Secretary is not liable.
Huh?
As per this speaking order, the principal secretary already directed. The first papers meeting, CST met, Kennard, not secretary. Head of the department. Authority.
Who has given you the work order? Huh?
PDO, block officer.
Who is to do the but who is to, as per Tamshir Ali, the head of department has to do
Head
it.
of the department.
So who is the head of the department?
Name is not, I don't know.
No, designation.
Designation, CST, Kennard, council head of the department.
Okay.
CST, Kennard.
Is he a party? Who is the you have not made him a party.
Not
No. You see, as per Tamshir Ali, the head of the department has to
affected by.
do the verification. So if you don't make the head of the department a party, how can Tamshir Ali be uh, complied with? Mr. Council, earlier order forget, earlier writ petition forget, that is gone, finished. End of the matter. That's why you file a new writ petition. In this writ petition, the head of department has to be there. So there are two aspects. You can either amend this writ petition, or you can withdraw and file afresh, whichever. Because I think amending might take time, but depends upon you solely. Huh? Okay, right. Mr. A. Boro, learn counsel for the petitioner. Says that the matter may be adjourned so as to enable him to make an implement application of the council
Council head of the department,
of the
CST.
council head of the department.
Kennard.
Come up PNR.
Okay.
In view of the prayer made by the petition council, this is the matter after 2 weeks.
I can get same. I just get a.
Item 10 also, the CHD is not there.
Not yet.
Same. You should have, actually, it's easier for you to, I know, either way, doesn't matter. Because that'll take time. And item 10 on the same order. You withdraw with liberty to file afresh is easier. Straight away we get passed. Okay. Huh? Item?
Item 99, correct?
Who is the senior counsel?
BJ.
That's it. Huh? Whenever you are free. Where is in which NIT? No, the present NIT date 18/6/24. Your technical bid has been disqualified. In your other work, you see, principles of natural justice have to be kept in a distance in contract matter. Except of course blacklisting and all, that's a different issue. No, that's a different issue. So in those you had participated in two earlier NIT, is it? And then what happened to those NIT? In pursuit to which NIT? What? Well, what did the tender, no, what did the tender say, the terms and conditions? Can a subcontractor participate? Not in the instant, the earlier tender. Then what happened? Then what happened? Which NIT? Please tell me the dates of the NIT. Tell me, don't just fly over. Just tell me the dates. Which NIT? What is the first NIT that you did? Date? What is the company's name? Where is it? Okay, this VOZ. What is this letter dated? Where do you get that? Page 34. You were in 36, stepping backward. We are on page 34, correct? Yes. So this is a letter issued by To whom? To that was, to that we, was. For this is construction of sensors, for performance security. No. What was the contract amount? Initial contract amount? Mr. Council, this is the contract amount between you and that was. Where is the contract amount between was and the government of Arunachal Pradesh? There's between you and between you and was. Mr. Council, this is a letter issued by was to you. And so when you say you, when you say that this is to notify you, it means that you're talking to this present petitioner, to you. Ah, correct. And for uh, at your quoted bid price, at your quoted bid price. Now, that is between you and was. Where is the contract between was and Arunachal Pradesh? What is the amount? You don't know. Cannot be. You mean to say he this was is the canalizing agency? What is the facilitating agency or what? What is it? Principal contractor. Ah. No, no. It cannot be, Mr. Council. How can it be? You look at page 34. Page 34, the government of Arunachal has asked you to submit performance security of 16 lakhs, 16 crore 74 lakh pesos. You have asked the same amount that was has asked the same amount from you. Yes. Then where is the question of where is the question of you being allotted only 40% or 49%? No, no, just tell me what is the so you were a subcontractor under was and you did 40%, 49% of the work. Then page so tender dated. You don't have I'm asking you a question. You can't reply. You only got the LOA. LOA in person to which NIT? Then, then, page, page. Where's the NIT? Again, you don't have NIT. Arre, none of your cases have NIT. What is this? Then what NIT are you talking about? Where? Yes, yes. Let me, yes. No, no, when did the 9/11/23? Yes. So, page 60? Yes, yes. That is why I need the NIT, the earlier NIT. I want to see the clauses in the NIT. Whether those clauses are there. What is the effect of those clauses? That is why you see that you are talking about the first contract work, correct? Under was. Now, you are talking about the fact that the approval of the government or someone is required, correct? No, no. So I want to. That is why we have to see what did the NIT say at that time. Maybe so. No, no. You see, yeah, you have to bring in everything that is there. You cannot pick and choose what documents you want to bring before this court. You have got to bring everything. Where do you have those NITs? You bring that. Page.
Page 11.
Page 11. Yeah. Clause 4.2 of contract agreement.
More than acquired. Also, second of this year.
Yes.
Here, mention about the approval, letter of an approval of the subcontract.
No, but then what it shows is that you have got to communicate the fact that you are subcontracting your contract. That is a requirement.
Yes, that's the therefore, so therefore, after that I will be perfect. I have approached the authority. I have taken prior. So there is the possibility that so they have certificate.
That's why I need the NIT to see what the NIT is saying. We have got to see what are, we have got to see whether it is in vogue or not. The the fact remains that it is an agreement. You cannot go beyond the agreement. And then we have also got to see whether that agreement was in terms of the NIT. So you bring the NIT.
And I
Where is the NIT where is the NIT? I don't have it. You are saying it is not as per the NIT. From where are you saying that? Have you seen the NIT? No, you just said that this clause 4.2 is not in terms of the NIT. So you have seen the NIT, it implies that you have seen the NIT. If you have seen it, can you give a copy to this court?
rejected by important. As first time I did it, I approached but they are producers, but some so they are they had a color of and also the color was
You see, we can only look into a decision, the whether it has been done lawfully.
Yes.
We cannot go into the soundness of the decision. Correct? So
I have
so technical bids have been opened.
I have participated I have been technically then
No, in this case, technical bid has been opened or not? So you have been disqualified there.
now that I have been disqualified and the date of date of all provided they have taken the for me.
We don't know. We'll have to ask them for that if they have had clarification. But one thing is clear, that question of principles of natural justice have to be kept very far. It's not like your normal case, business, service rules or service cases. It's slightly different in contract matters. You're not supposed to be given opportunity to explain each and everything. They can do their own inquiry. But of course, there has to be a basis for coming to a decision. That it doesn't mean that everything has to be asked from you. It can be asked from some other authority. Let's see. Okay, so now you are now agreed with which NIP? Where is the impugned decision? Yes. Where is this 2.6, 2.6 Yes. So misrepresentation. Will your case come under misrepresentation? According to you. Subsequently, you have got the approval.
development center. So those are sectors. Only because of that idea that was there. And in fact, the part of the event, the Russian leaders, after the computer sector, they did not take any action against the regarding the development, etc. But other things that I have considered as a protection. But I could not submit the other standards by the time other things were open. So the case were advertised concern.
Yes, Mr. Gogoi.
Without the record, particular verification is called for from the concerned authority to have issued the certificate. Then, take it certificate. But one thing is sure, my lord, that in page 180, the main paragraph, it has been stated that petitioner has not even completed the work. He has now already submitted that he has abandoned it.
He has abandoned the work.
Yes. How that can be considered as an experience? So you just Kolkata abandoned. No, that's not statement has been made there.
Arunachal Pradesh.
Yes.
I think we need to physically verify.
Yes.
Arunachal, the road is really there. Okay, good.
So, well, this letter dated 4/10/2023. I can take it, put it on our board. Everything will be clear. Page 181, 4/10. It is clear.
What about the financial bit? When is it going to be open?
Yes, but when if it is open, it will not have my tomorrow if it is kind of found to be technically viable, but I would put bold that it is open.
You don't finalize the tender.
That
You don't finalize the tender till.
also fact. We will post it, may not in that case on Monday. It I will come up with it. Okay.
Right.
But I
Right,
will file a short affidavit by Monday. But we post it on Monday.
right, Mr. PJ Saiki. Senior counsel for the petitioner to submit that the petitioner has participated in a contract work valued at rupees 164 crore approximate as a subcontract. In respect of, in respect of the NIT issued by the Executive Engineer, Zero Highway Division, PWD, AP, Zero Arunachal Pradesh. However, while participating in the NIT dated 18/6/24, in respect of the contract work under the Rangier division of the PWD, the petition's technical bid was rejected on the ground that prior approval of the government had not been taken for the subcontract work done by the petitioner from the principal contractor, who was that name. Page 36, page 36, his name is there. Okay, by the Public Works Department, Government of Arunachal Pradesh, by the VOZ, ROZ, HDENIE. How do you pronounce this? Vosrod Jenny. Yes. Next, sir. The petitioner's counsel submits that the petitioner was not aware about the requirement of seeking the approval of the PWD Arunachal Pradesh as a subcontract, and despite and in view of the same, the petitioner was the petitioner approached the Vasco Deni, who issued work experience certificate dated 23/11/23. Okay. Then you said the approach the PWD government, PWD government. You have said work experience certificate is dated 23/11/23. Ah, and what is this 23/11/23? Where is this page 23? Page 70. What have I said? No, no, who issued the page 70? Where is the approval? Who issued the approval for subcontracting of 49% of the contract work to the petitioner from Vosro Deni, for an amount of rupees 164,14,27,000. Next part. Further, experience certificates were also issued on 15/5/23 and 4/12/23. The petitioner submits that the petitioner's approval letter and work experience certificate have also been accepted in other accepted by the NHIDCL and PWD Road, Assam, for other contract work. So as such, the petitioner's as such the disqualification of the petitioner's technical bid in pursuant to the NIT dated 18/6/2024. Why the technical bid evaluation meeting minute dated 5/8/2024 should be set aside. Bracket page 180, okay. Next part. Issue notice. Issue notice? Oh no. Issue notice returnable in 5 days. Mr. Pigo accept notice on behalf of. No, ministry you cannot take. But it is represented by the CBT National Highway Assam. Okay. They have an office in the same. Okay. Accept notice on behalf of all the responsible. He submits. Mr. Bigo submits that he will produce the letter dated 4/10/23 issued by the chief engineer bracket HW zone close PWD Arunachal Pradesh and file an affidavit by Monday. This is the matter on huh? In the interim, the respondents could not finalize the tender in terms of the NIT dated 18/6/2020 till the next day. Item 3. What is this? Okay, 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 yes. Okay, right. You haven't given me the IA. Let me say, borrow learn process for the petition. Applicant who submit that Shri Akash Deep IAS, Principal Secretary BTC Pokraja, should be pleaded as respondent number 2, inasmuch as the earlier incumbent has left the post. So, sir, the prayer of the petitioner, the applicant's counsel is allowed. Shri Akash Deep IAS, Principal Secretary, BTC Pokraja, is pleaded as respondent number 2. Applicant shall submit a corrected memo of corrected cost title to the registry within 3 days. In 3 days, the I is accordingly allowed and disposed of. Then in the main contempt case, you write in view of the order dated 13/8/2024, passed with IAC 2596/2026. P. Akash Deep IAS, Principal Secretary, BTC Pokraja, is impeded as respondent number 6. Issue notice to the newly impeded respondent number 2. Petitioner takes steps for service of notice by registered post daily within 3 days. This is the matter after 4 weeks. Yes, madam.
Work order was issued by Deputy Commissioner. So first of all, we can certificate the bill. Then after, they send to the department. They do not certificate the bill.
Huh?
But if we do not authenticate the bill,
Who is authenticated?
work order was issued by district Deputy Commissioner. So first of all, he must authenticate the bill.
How was the work done under the supervision of the DC?
So Lordship,
Who supervised the work?
Lordship work order was issued by the district.
So you file an affidavit, madam. What is so difficult in filing affidavit? Yes.
Already went to the PNRD department for additional funds.
Who are these 5 registered firms? Who are they?
Sir, file
So how do we know that the petitioner is one of these 5 firms?
that respect to will taken.
That's what were you doing?
Divestment of PNRD department has to release the fund.
Someone has to verify, no? You have to verify it. DC has to verify it. Why are you not verifying?
Will taking, sir.
Look,
However,
you see, you're only taking instructions. Why don't you give them instructions?
Hello?
Why don't you give them instructions? Why don't you instruct your clients that, look, there's a claim, please verify. Tell them that is your job. have to take instructions. That is not the way.
Reply to them.
Sometimes you have to give instructions also.
Moreover, in this matter, he has no sabab, ethical copy, but so he could not take the instruction. ये क्या बात? तो ये ना ठीक.
Yes, you have to give them personally. Yes, madam. What's happening? Why is the payment not being made? Who's your senior? Rakesh? Dubai. Okay, right. Petitioner counsel is present. Mr. G. Bakalian submits that he has not been given extra copies of the writ petition. Mr. A. Todi, non-counsel for the petition, submits that extra copies will be provided within the course of the petition. Ms. N. Bora, learned counsel for the respondent number 2, and Mr. G. Bakalian, uh,
1, 4, and 5.
1, 4, and 5. Yeah. No, and Miss N.B. Kayesta, appearing on behalf of Mr. R. Dubey, learned counsel for the respondent number 6, shall file the affidavit. No, are given 3 weeks time to file the affidavit. This is the matter of the 3 weeks. Same order. Same order. Everyone is the same. Kayesta is there or not? No, she's not there. R. Dubey is again there. Same order. Same order. Extra copies will be. What is this? That so what do you want? Hmm? Okay, so you're challenging the work, the balance work given to the respondent number 4.
You have to take instructions related to the completion of the work. Yes.
Huh?
You have to take instructions, whether he has completed 85% of the work or not, then what is the current status, Doctor? But it sometimes means
Whether the work has been completed or not.
Doctor, as stated by the petitioner that 85% of work has been completed.
No, the issue is not that. His prayer is that the work allotted to that private respondent should be set aside, the 15% work. So you have got to see how much work has been completed by the private respondent. Whether this writ petition has become infructuous, because if he has completed 100% of the work, nothing remains. Correct? That's the only thing.
Sometimes maybe granted, Doctor.
Mr. Triple S. Raman, learned counsel for the petitioner, is present. Paul Turner is present. Miss R. Parva is also present for the respondent numbers.
Doctor, all the response.
All the response. Ms. R. Parva shall obtain instructions as to whether the respondent number 4 has completed the work allotted to him. And if not, the percentage of work done by the respondent number 4. When?
2 weeks till.
Why this for status? What is it?
Lordship. Lordship, he should fix a matter on 22nd, Lordship.
This is a matter of 20 seconds.
If I
Let's find
recommend-
out. You see, the thing is that if he has completed his work, because it's 23, everything might have now everything might be infractions also.
My lord, item number 7 and 8. On the last occasion, my lord had called for the records pertaining to the tender process. That record is yet to be received. An accommodation may be granted.
No, we have fixed too many Monday, Tuesday. Huh? I know. We've got lots. We'll fix it after 24th, 25th, 26th. Okay. Uh, uh, um, Miss
U Sharma,
U Sharma, Land Council appearing for
respond numbers 1 to 4.
1 to 4. Pays for adjournment on the ground that the official records have not been handed over to her till date. Or Miss, what is the name? Miss DJ Bora appears for point number 5. This is the matter on 27th. Item 8 also same order. Interim order to continue till the next.
Obliged.
That's what of the item. What is this IA for? No, we'll dispose of the entire thing. We'll dispose of the entire writ petition. We won't, you see, hearing the IA will be as good as hearing the entire case. So there's no point wasting time. We'll dispose of the entire case. Yes, I'm ready. Now start. You start. Oh, you're the petition. Okay. You're the private respondent. For what? For modification. So he's a respondent. Then you come this way. Oh, he's not filed a treatment application. Oh, he's not a party.
It's not a party.
Mr. Counsel, are you a party here?
No.
Then? IA cannot be, IA cannot be considered unless you are a party. You have to file an application for impeachment, then only your case will be considered. You are affected by the petitioners, by the interim order. Well, unfortunately, you have not, you should have filed an application for impeachment along with this, if you want, but then it's not been done. So you can listen, just sit there and listen. So IA, so we'll have to dismiss later on. They should not have allowed, yeah, I mean. Huh? He's not a party. Yes. What is your case? Just a minute, huh? Okay, this is MD Bora's case. What has happened to her? Okay. Has it turned out to be a bad case for her? Okay, anyway, just a minute, just a minute. Okay, so where is the affidavit of that person? One 93. One 193. 193 is affidavit in reply. Affidavit of position filed by on behalf of the respondent number 3. Huh? No, wait. Affidavit filed by Anurag Ananda. He is not a party here. Yes, doesn't implicate the petitioner.
You are not the highest because
What about the issue of that signature?
Hello.
Page 56. Yes. Yes. Where are you reading? Where are you reading? Yes. Yes. Yes.
What is therefore it is simple. And follow the defined transaction to check follow the previous system. It is submitted on this. As far as the situation is
Yes.
submitted of the system. It is the key.
Yes. Yes.
As far as it is a better system of it. And very simple. Made by the department.
Yes.
Perfect. It's a single part. With for as per election, like technical, for legal election, it's submitted. And if
Yes.
First of all, site plan or proper site plan. Now I don't see the electrical sheet. So it is the bit of the sheet of sheet.
Yes.
The bit of well, well, it's the site.
Yes.
Site plan certified by. And I don't think it is also
Page.
bit of it. That's the first bit.
Site plan certified by an engineer. It does not say anyone in particular.
Well,
48, yes.
the things that it should be referred to by the comparative case.
Yes.
Accordingly, get depends on the bit of
Which, which, which serial number are you talking about? Page 48?
or bits, Excel is 12, point number 12
Yes.
of the site.
Yes. Oh, you wanted to show me that is NHSC.
Here, with quite some
Page. Page number 36. Yes.
point, having some people, sometimes and it's requirement. All people for sometimes and it's requirement as complete with
Within.
with it seems all responsibility for the all of gets prepared or say that what is and final it that is by the it is part for all the it has now that's
Because of?
it was the original bit of
No. In the rebate, what are they relying on? The respondent?
on the like
Page. Okay.
just think that records the audio bit on the page seven they are thinking where the which you offers how they right then the give compared to that and the original bit of things that we have something that has so within that that's there is another bit to the actual bit is the not the higher
Yes.
the actual but trying to explain the member of the
That is not true.
that is not true. But another point is page 57, which has relied upon with sniper engineer. Now he's saying that they have to refer to the previous big document for detail. As per annexure C of document, that whole detail has to be filled by the bidder himself, not by the authority. So for since there was a defect, since we didn't get any proper application regarding the first bid, that's why we should rebid, we gave a clarification that this has to be done. This page 57, where it says the site plan signed by assistant executive engineer.
But that C still remains.
But C remains. C has only the name. For clarification, we have annexed this document. Even though C remains, but C is this annexure C checklist of bidder eligibility criteria and technical bid to be filled up by the bidder. Even though it's there, but since we have clarified that you get the site map countersigned by assistant engineer now. You have completely clarified that. It's not that only there are other builders also who have submitted that clarification. They have even submitted the site map countersigned by the assistant engineer now. Yes. Because we are not challenging that clause alone.
No. Why should he challenge? He's relying on this law.
He's relying on this stuff, but since we have
Yeah, you, in your NIT, you have allowed for two, two officials to sign.
no, we have not got to official file. We just gave a clarification that the matter when you submit a site plan in a rebate, you get it countersigned by the accepted executive engineer. You get it countersigned by the executive engineer. That's it. Where is relying NHSC or not? The NHSC says site plan to be countersigned by engineer. It was before also. This document NHSC was before also the previous bid.
In the previous bid,
There was no
in the previous bid, site plan signed by an engineer was good enough.
was good enough. Since there was no proper application thereon, we made this list of documents, which is 27, clarifying everything. So that we get a proper application for that. The reason for rebid is that no proper application was received on the previous bid. Since no proper application was in previous bid, we made a clarification of it.
So this clause out here, site plan certified by an engineer,
Yes.
it is a superfluous clause, redundant clause.
No. At first, when the connection,
When all along, it was a clause that could be acted upon. Now suddenly, it cannot be acted upon. Why? What is the reason?
the reason because most of the bidders, the earlier bids, they have no proper application regarding anything of it.
No, I'm not on anything. I'm only on this engineer, signing by engineer. If it can be signed by any engineer, assistant engineer or AE or why do you require a specific engineer to sign it?
Because it,
What is the justification?
because the
No, you see, you are the author of the tender, okay. You are the best person to interpret it, okay. But what is the basis for you to say that there should be a specific engineer to sign it when your NIT provides for any engineer and also specific engineer? So why should it be only confined to the site plan being signed by a specific engineer?
positive impact that technical
Agreed. What is the basis? What is the basis for coming to to such a decision?
uh, the site plan signed by different engineers,
So how does it matter?
make it more clear.
Where have you said that?
But-
Please do not make submissions beyond your please.
But the fact we already annexed the document, where document, we just keep noted, we keep it noted. We already clarified everything. It's not that we only clarified the section engineering, we have clarified around 27 points. We've clarified everything. We have followed everything. Since he has,
Nisiran, you'll get your turn.
he has complied,
He's got ants in his pants. Yeah, very, if your turn will come, don't worry.
submitted the document, I think we have filed the one. The academic opposition filed with the Superintendent of Site. At verified, it says that the reported that state that 2012-2023 e-bill was published for various shops located within the Lakshmipur district. Thereafter, on 23-2, issue a rebid as the tender company did not receive any proper application and all the bids were rejected. It is pertinently mentioned herein that in the re-rebid notice dated 23-2024, the authority issued a list of documents to be submitted along with technical bid, which in fact formed a part of the appropriate rebid document. From the perusal of the state list, at point where the state list states the site plan duly signed by assistant executive engineer. The petitioner was well aware of the state list as it was part of the rebid notice dated 23-2024. The phone invested Annexure C of the bid document pertains to checklist of bidder eligibility criteria and technical bid. The checklist is to be filled by the bidder himself. Tender company thereafter scrutinizes the document submitted along with the checklist. Upon scrutiny of the state document submitted by the petitioner, the site plan was not found in conformity with the listed document. It was part of the re-tender notice dated 22-2024. More particularly, point 22. Clause 27.1.5 or the bid document states on which basis technical is evaluated. Clause 27.1.5 speaks of submission of specified documents. From the perusal of the clause, it is seen that the petitioner, even though submitted a site plan duly signed by the assistant engineer as per earlier tender 2012-2023, no proper application was.
Tell me one thing, this checklist for bidder eligibility criteria in technical bid, is NHSC, is it a mandatory requirement?
Yes, because they are mandatory terms, we have given this op, they have to fill up. Thereafter, we scrutinize by this document one by one. What they have given, what they have not.
So that is a mandatory requirement. Now you tell me, all these documents to be submitted along with the technical bid that is mentioned in page 57. Are they all mandatory requirements?
This is a mandatory. Because
Then tell me, is there any document or anything that is not mandatory? And from where have you said that these are all mandatory? Where have you said in your affidavit that all these 1 to 27, basically in every page of the tender bid document is mandatory? Where have you said?
at page 28, the documents compromising the bid you're talking.
Huh?
Documents compromising the bid, page 28.
With
Documents which have to be attached with the bid you're talking,
Ah.
they're submitted, which says, clause 2.2, H2O certificate operator.
Which page?
Page 28.
Yes.
Yes, this is the documents compromising the bid.
Ah.
So since this says the document, they have to submit all these documents with along with their detail, the lot. Correct? So, and at page 58, if you may not take 57 may not take up, it is comparatively same as this points clause number 6. H2 certificate is there. At point 12, H2 certificate is there. 6.2.1 speaks of duly filled up application format as per annexure A. Scan copy of duly filled up as per annexure A. This all are same, your lot.
Same with what?
Same as this original, the big document with component clause 6, which is that document which is
Where is this clause 6?
page 28,
Clause 6 documents comprising the bid. So,
compromising the page 6.2.1, your lot.
so
Duly filled up application format as per annexure A.
Ah.
Now, if I may take a lot to page 57 directly,
page 57, yes.
yes. Scan copy of duly filled up application as per annexure A. So
Ah.
since these are so, these clause 6 documents are mandatory, so this document also becomes mandatory. This is only.
No, but you see, no, sorry. One is scanned copy of duly filled application as per annexure A.
Yes.
2 to 27, are they part of annexure A? Yes. So annexure A is there and then 28 is there, okay? Six point two point nine.
6.2.9 is description of site on which proposed site shop is to set up. Now, if I may lordship, there is no mention about signed by support at all. But as per clarification 57, site plan duly signed by. That's the clarification. we get.
That's that. Page number? 90. The same thing is there. So there are two pages. One has only clarified it a little bit more, it appears. But then it says that, you see, the thing is that this page 20, this serial number 22 is not a part of NHSC. If it was a part of NHSC, that NHSC clause 12 would have stated by assistant executive engineer. And yours has been signed by? Supposing it was signed by an executive engineer, then what happened? Or by a chief engineer, then what happened? No, I'm asking you, what would happen? Does it have to be signed by an executive assistant engineer? Can it be signed by an executive engineer?
Whether
If it is signed by, supposing it is signed by chief engineer, then it will come under clause 3 or not? Any engineer?
but that the operative system or whether they want to accept that different type of.
No, you have to give meaning to each and every clause of the tender. You cannot just say that I'll give whether that I will not accept chief engineer's report, but I'll accept only executive assistant engineer. Some assistant executive.
That's why, that's
Okay,
the reason a lot. Since earlier, site plans were signed, site plans were given, this was, given, with no proper. To get a proper application and so to make things more easier to get proper, it was not for. This clarification, the even petition or that needs to, comply with all the that's given. It's not that even other bidders, they have submitted this, site plan signed by the executive engineer. The other principal who have applied the same. A petitioner cannot make a come and say that I have not done, so my bid cannot be rejected. Then other people who have even complied with it.
Is it a curable defect? Is it a curable defect? Supposing it is a defect at all. Is it a curable defect? The site plan is not going to change just because it is signed by the engineer in chief or the chief executive, chief engineer or by a junior engineer or whoever. Is it a curable defect? Will it change?
Then there is a clause, waiver, there is a clause about. Oh, thank you about it.
Page,
Page 36. Clause 19 about.
yes. Clause 19, yes.
19.16, no deviation terms and conditions that state of the bid shall be accepted. 19.2 says, tender bid comes to overthrow the bid, reserve the right to waive minor liquidation.
So whether it is a minor or a,
That's the you have to decide about what's the minor or the major.
why don't, so what have you said is the affidavit?
We have said that since the site plans are not going to give a clarification that this is signed by the specific person, they have not signed it, we'll get it on that one.
That's all. I think he's staring me at me, you know.
No, my lord,
Not blinking at all.
my lord, if I have understood their case correctly, then they are saying that they have submitted the document in terms of annexure C. And since annexure C is also a document under the new, under the fresh EB documents required, therefore, my lord, we were at a bona fide impression that this is. Now, my lord, let us see whether page 50, the clause which they are relying is in fact the clause pertains to submission of document or something else. My lord, I do not know why this fact was, my lord, when they were time and again referring to page number 48, conveniently they are not drawing this court's attention to the name of the column.
Name of the
Column. My lord, column number 1, serial number, my lord will ignore. Column number 1 is basic requirement. Column number 2 is specific requirement. Column number 3 is documents required to be uploaded. So the document column is column number 3. Now, my lord will kindly come to page number 50.
Hmm.
My lord, the column which they are referring, it's not the column pertaining to documents to be uploaded. It is the column pertaining to requirement.
Correct.
The documents to be uploaded is the next column.
Correct.
That is land holding, Jamabandi, valid lease agreement.
Huh?
Now, my lord, whether they comply with the clause which they are harping on, let us see, my lord. My lord will kindly come to page number.
No, you're dealing with specific requirement.
Specific requirement, my lord, this, my lord, I'll come to specific requirement. I'll satisfy your lordship, my lord. I'll not skip or escape any question.
No. So please don't take too much time.
Yes.
That's all. That's all. My only request to you, please don't take too much time because don't repeat everything once in a while.
My lord, I assure to this court, my lord, I'll not make any repeating.
How long will it take?
My lord, will bear with me for 10 minutes, at least 10
10 minutes.
10 to
No,
15
no.
minutes. Now, my
10
lord,
minutes, 10 minutes. No more.
my lord, IST is also at times interpreted as Indian stretchable time.
I know.
Now, my lord, documents required to be submitted is the clause number 3. So, my lord, for documents required to be submitted against clause number 12 is a lease agreement
Ah.
regarding the site plan.
Ah.
Now, my submission is this: they fail on this very count itself. I'll check it. My lord will kindly come to page number 102. It is their writ petition, my lord. I am referring from their record. My lord is there at page number 102.
I'm still finding, I'm still looking for it. Yes.
My lord,
102.
this is the lease agreement.
Yes.
Now, this is a notarized lease agreement.
Yes.
This is against the statute laid down by the parliament.
This is again.
Against the Indian Registration Act laid down by the parliament, it says, my lord, something which they have brought before the writ court. It's my duty to bring it to the notice of this. This is a violation of section 17 of the Registration Act. I'll place a judgment of the Supreme Court.
Who's there? What is that is not the issue here.
Now, my lord,
That you're not the authority to decide whether his bid is, you cannot go into issues that are not an issue taken up by them. You're not the authority, sorry. You are only a bidder.
now, my lord, something which comes to my
No.
note, my lord.
Please do not waste time.
My-
No, I'm not
Then,
listening.
my lord, the site plan certified by an engineer at page number 50, my lord, it does not say whether it is an executive engineer, superintendent engineer.
Correct.
It is not any engineer.
Correct.
It is an engineer.
Correct.
Now, this is a requirement.
It's a specific requirement.
But it has got nothing to do with documents to be submitted. Documents to be submitted against this clause is a lease agreement. Now, documents to be submitted, your lordship will
Tell me
come.
one thing, Mr. Counsel, in the earlier tender notice that was there.
Yes.
This was the only requirement. In the earlier tender notice,
My lord.
prior to this NIT,
My lord.
that signature by the assistant executive engineer was not there.
My lord.
Only this thing was there. The same thing.
Now, my lord will kindly come to, my lord, what goes into the mind of the technical committee of the tender inviting committee, my lord. I cannot, my lord, gaze into their, my lord, thought process. My lord, I am making my submission as to whether they have complied with the condition or not, because an exception cannot be called out for them. Because might
No,
be
no,
there.
that is their job. That is their job, not your job.
My lord,
Sorry, you are just a tenderer.
now,
That's why you have got a very small role to play here. You have got a very small role to play. Because you are not the authority to decide whether his bid, disqualification of his bid is correct or not. You can give some submission, but you are not the authority. Just remember that. You can help the
because,
court.
my
That's
lord,
all.
I am affected party, my lord.
Maybe you are affected.
Now, my lord,
Maybe you are affected.
now this is, my lord, because I have, now, my lord, this does not say, my submission is that this clause it does not say whether it is an assistant engineer. It says an engineer, not any engineer.
Correct.
Now, an engineer is explained by a subsequent corrigendum And that corrigendum, my lord, will kind.
It is not a corrigendum.
Corrigendum, that's, my lord.
It is just a list. It is just a list.
As a clarification, I would say. My lord will kindly come to that page, my lord, documents to be page 57. Now, page 57. Now, page 50, documents to be submitted along with the tender fee. Now, they are harping on 18. Annexure C, D, and E does not say, my lord, it in itself is not a document. This is a checklist. In that checklist, certain documents are mentioned. In those documents are at column number 3. Those in itself are not a document. The intention probably of the tender, my lord, of the tender inviting committee is that before submitting the tender, you check that whether the documents as stipulated in the checklist, you have submitted those documents or not. These are not document per se. Now,
No, you see, prior to this, this notice inviting tender 23 to 2024, there was an earlier NIT of December 23.
Hello.
Now, in the December 23, was there any requirement of the site plan being signed by assistant EE?
now,
And another thing, was there annexure C in the earlier NIT?
now, my lord, those the record will speak, my lord,
No,
for
no.
the earlier NIT. my lord.
That is why, you see, that is why. And these are the questions that will have to be gone into.
Now, my lord, if I understand it correctly, my lord, at page 57, documents to be submitted along with the technical bit, then read with clause 22, site plan duly signed by assistant executive engineer. So, my lord, the clause as it stands, it means that somebody who submits a site plan which is not signed by an assistant executive engineer is not qualified. So, they have a basic problem with this particular clause. They are contending that this clause should go, and that though that does not speak of page 48 of any document, but a requirement that will prevail. In that case, my lord, they ought to have challenged clause 22, because so long clause 22 exists in the tender document, they by their own admission are not qualified.
Okay.
Now, my lord, now the lease document, my lord, I have already indicated, my lord, that is because there's a judgment of the Supreme Court which says that if somebody submits a unregistered lease document, a tender was rejected on that very count itself.
No, that is not an issue here. I'm not taking that. I'm not
They have annexed the document, my lord.
So what? So what? When you're not the technical bid committee, that is not an issue here. You want to file a writ petition against him, you file. This is his writ petition, not yours.
No, my lord, because they have failed in some counts, my lord. Had there been closer.
They have failed in some
lord,
counts,
I'll-
but that
I'll-
is not an issue.
No, my lord. I'll just rely on one or two. And moreover, my lord, in their entire writ petition, my lord, there is no averment to the effect that it is against public interest. That if the tender is allotted to me, then it is against public interest. There is no averment. My lord, I rely a judgment, my lord, rendered by your lordship, where your lordship has dismissed a writ petition on these two ground, my lord, that a particular clause was not put to challenge, and that there was no averment that it is against public interest. My lord, this is WPC 2001 oblique 2023. I'll give a copy, my lord. My lord will kindly come to para number 17, 18, and 19. Your lordship, after referring to Jagdish Mandal and Uttar Pradesh Evam Vikas Parishad, had laid down at para number 19, your lordship. In the present case, there is no challenge to the clause in the NIT, especially the clause providing that no bid beyond 10% of the minimum value could be accepted. And then, my lord, with regard to public, affecting public interest, my lord, your lordship has told at page number 10, internal page number 10, in the middle, the line which starts with also. Also, there is no averment that public interest should be affected in awarding the tender to the respondent number 5. My lord, I have searched in vain in their read petition, there is no averment to that effect. Now, my lord, I'm also relying on, my lord, a couple of more judgments, my lord. 2022, 5 SCC 362, para 25 to 26.
2022, 5 SCC,
2022, 5 SCC 362, para 25 and 26.
okay.
So, my lord, the para 25 is a narration of all the previous judgment, and para 26 is the finding in this particular case, which your lordship would find at internal page number 384.
Yes.
The above mentioned statement of law make it amply clear that the author of the tender document is taken to be the best person to understand and appreciate its requirement. And if its interpretation is manifestly in consonance with the language of the tender document or subserving the purpose of the tender, the court would prefer to keep restraint. Further to that, the technical evaluation or comparison by the court is impossible. And even if the interpretation given to the tender document by the person inviting offer is not as such acceptable to the constitutional court, that by itself would not be a reason for interfering with the interpretation given. And my lord, one more, that is 2019, 14 SCC, page 81, para 37,
page,
page 81,
yes.
para 37, 38 and 39. It primarily says, my lord, that the author of the document is the best person to understand and appreciate its requirement. So, my lord, whether an assistant engineer or an assistant executive engineer, my lord, it is for the technical committee to decide it, my lord. And my lord has posed a question, my lord, that if it is signed by an superintendent engineer, my lord, suppose, my lord, to draw an analogy, my lord, suppose for a particular post, the qualification required is BA. Now there are two candidates. One is master degree and other is higher secondary. My lord, I don't think, my lord, there will be any objection in recruiting the master degree candidate, but there will definitely be an objection to recruit the higher secondary degree candidate. Now, my lord, this is the judgment, my lord, which I am relying because, my lord, on their ex special, my lord, their lease document was unregistered. Supreme Court
No,
tender
I am
matter,
not on that. That is not an issue here.
tender matter, my lord.
That is not an issue here. You are not the bid evaluation committee. You are just one of the tenderers.
My lord, nowadays, my lord, because of this e-bid system, one thing is good, my lord. Nobody can play any hiding. What document I upload, they can see all the documents. What document they upload, I can see all the documents. So things are nowadays very
So
transparent.
that is a different issue. You file a writ petition if you are agree. With regard to that.
My lord. And the last judgment, my lord, that I'd like to press in service is that, my lord, this is a three-judge bench judgment, my lord, 2023, SCC online, 671, para 48.
2023 SCC online ST.
SC 671, para 48. I'll give a copy, my lord. My lord, will pardon, I'll give a copy, my lord, it's there, I know, but I'll just, my lord, because only one paragraph, I'll just read it, my lord, page 48. This court being the guardian of fundamental rights is duty bound to interfere when there is arbitrariness, irrationality, malafide, and bias. However, this court has cautioned time and again that courts should exercise a lot of restraint while exercising their power of judicial review in contractual or commercial matters. This court is normally loath to interfere in contractual matters unless a clear-cut case of arbitrariness or malafide or bias or irrationality is made out. One must remember that today many public sector undertakings compete with the private industry. The contracts entered into between private parties are not subject to scrutiny under writ jurisdiction. Because contract between private persons are not subject to judicial, they are not amenable to writ jurisdiction. No doubt the bodies which are state within the meaning of Article 12 of the Constitution are bound to act fairly and are amenable to writ jurisdiction of superior court, but this discretionary power must be exercised with a great deal of restraint and caution. The court must realize their limitation and the havoc which needless interference in commercial matters can cause. In contracts involving technical issues, the court should be even more reluctant because most of us in judges' robe do not have the domain. The court should not use a magnifying glass while scanning the tenders and make every small mistake appear like a big blunder. In fact, the court must give fair play in the joint to the government and the public sector undertaking in matters of contract. Court must also not interfere when such interference will cause unnecessary loss to the public. So this is where, my lord, one point which has come up, my lord, because the previous EB, where this annexure C, these are generally, my lord, these are more in terms of a general condition. The specific conditions came later, my lord. That is by virtue of that page 58, documents which are required. Now, my lord, when a general is pitted against a specific, the specific will always override the general, my lord, because it has been clarified that an engineer mentioned in annexure C means this.
It has not clarified. It has not said that the engineer mentioned in C, annexure C will be this.
But my lord, that is how, my lord,
That is how you have interpreted it.
this is
But that is not how it has been worded.
neither, my lord, page 58 is because they are referring to annexure C. Page 58, my lord, it is also not worded in a way that the basic requirement mentioned in annexure C will be constituted to be the documents furnished along with the tender. Because the documents to be furnished, there is a different clause in.
Look, you are the one who brought to the notice of the court, the column,
Yes.
the heading.
Yes.
And for that specific requirement, that word specific requirement has been put in that annexure C.
But
What do you mean by specific requirement? Does it mean general requirement?
my lord, requirement, my lord, I'll come to the, my lord, but the documents, because here the dispute is with regard to the site plan, the dispute is with regard to the document,
And what is
and the
what
document,
and what is the specific requirement under serial 12 say?
the requirement is that it has to be signed by an engineer. Now, this requirement, my lord, there is no bar, my lord, to whatever I understand, subject to correction, my lord, there is no bar on the part of the authority to further clarify or
No bar, no bar.
there is no bar, my lord. So, my lord, there might be some bidders who had site plan signed by an engineer, but they did not participate. Maybe because the site plan is not signed by an executive engineer, they have gone by.
That is a different thing.
No, my lord, these are things, my lord, because,
He has participated.
my lord, because, my lord, an exception, because it has to be for, otherwise it has to be for all the bidders, my lord.
No. You see, the question of all bidders will occur only when an essential condition is thought to be relaxed. Then it has to be relaxed for all the bidders who have participated, not for those who have not participated.
My lord, but my lord, if somebody challenges a clause of it,
Then that's a different issue. When it has been relaxed after the bids have been submitted and after the last date of submission of bid, that's a different issue.
Because my lord, the basic thing, my lord, whatever little I understand, my lord, as long as clause 22 at page number 58 remain, they by their own admission, because it is
They
their
don't admit, they don't admit.
yes, in their repetition,
What do they admit?
that their site plan is not signed by them.
Oh, that's what they admit.
Ah.
That's
So by
what they
their
admit.
own admission, they don't comply with that requirement.
No, they are, because they are relying upon another clause in the NIP.
But that clause, my lord, that clause does not pertain to documents to be submitted, my lord. Whatever call your lordship will take, that's my submission, my lord, because I have told the
No,
heading.
I am questioning you because I want some more information.
Yeah,
That's all.
because my lord, that annexure C, my lord, annexure C is a checklist, number one. Annexure C, the mention of annexure C in page 58 is for the limited purpose to ensure that the bidder submits the document. Now, what documents they will submit? There is a specific clause. Against clause number 12, they are to submit lease document, which they have submitted. They cannot, my lord, for the site plan, for the document pertaining to site plan, they cannot rely on clause 12. Because the documents against clause 12 is the lease documents and the other documents pertaining to the land. In fact, my lord, page 58, clause 22 is independent of page 48, clause number 12,
Page 58.
57. Page 57 talks of documents to be submitted along with tender bid. 22.
Just a minute. Let me finish.
Now, my lord, so therefore, my lord,
You have taken more than 10 minutes. How much more time? There's no point going around the bush.
so my lord, these are my specific grounds. I have, my lord, I have relied.
Given 4 decisions.
So don't say I could lay my hands on, my lord, as regards these things. And
That 4 decisions are containing many other decisions of the Supreme Court. So altogether, you have already relied upon 12 decisions.
the decisions which has been quoted in this
Yes,
court,
yes.
those will be more than
In that Agmatel.
more than 12.
I know.
Those, therefore, my lord, I have not relied on because your lordship has read it.
No, I've not read that. For me, I'm just learning.
No, my lord, therefore, I have not relied on all those Jagdish Mandana because umpteen number of time your lordship must have read it, my lord. So only the new ones which has come, my lord, that I have relied on 2023, 2024. And only one judgment that specific, general and specific, the specific will override the general. This is on this, my lord. 2010, 4 SCC, 498. 2010, volume 4 SCC, 498, para 12, within bracket, Roman 4. To be specific on that.
What is the number? The citation?
Citation is 2010, 4 SCC,
2010 for SCC
498,
498,
para 12,
para 12,
within bracket, Roman 4.
2010 for SCC 498,
Absolutely.
para 12.
Luckily, there is no capital A. I am deeply.
Yes, you are saying. Wait, just a minute. Page 56. Yes.
What is the DP and the DP should follow in terms of the time. My lord, so what will come of this actual are mentioned. Right. 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 This is not connected. What will I don't know. Or it is or extra bit respect for the original or level of the detail. It's so what will come is very it for the purpose of the detail. But the detail is for anybody to submit which option is signed by the so matter the what the of making the outside. Verify or
But they being the author, can't they change the conditions as they like?
data that it's like that like one part one step is data.
No, I'm not on that. But they can change. They are their money that's going to be spent. They, uh,
Data the thing has not a mandatory but it's just like but point number 7 is sort of you you have to follow the option that they can
point number 17.
of the original picture. Okay. Compliance method. All these things for compliance but this 15 so that we are got to think of this thing. I don't know what to already of it get me. That before that this type of case.
No, they can participate provided they have the minimum qualification.
Because there's a
No, it's like you having supposing they ask for a B.Ed pharmacist, but a degree pharmacist who has never done B.Ed for diploma, then he cannot because he does not have that. But if he had done that and had the degree, then
Higher there is no problem.
no. But there are some different ways of looking at different things. You see, like it's like this. Like if supposing there's a diploma, say pharmacist diploma, then that is the requirement. Now, can a degree diploma, person having a pharmacist degree, can he apply?
The specific, he must possess that pilot.
Yeah.
He must
So
possess the
So
minimum.
that's what. So if he doesn't have that diploma, will he be barred? He doesn't have the degree pharmacist doesn't have diploma. He has bypassed that. He has gone above that.
Pilot,
Think about it.
this is like a recruitment notice ballot where initially all the interview procedure were same, only the qualification changed from higher secondary to BA. Now, whether my lord, whether the employer can change it or not. Only to that extent, only a qualification was changed.
it is the
It is there, it was there, my lord, it was published, that to page 58 was not withheld from any party, my lord.
Anyway, heard Mr. R.B. Goswami, learned counsel for the petitioner. Also heard Mr. R. Gogoi for the excise department.
Four.
And Mr. M. Biswas for
For the private respondent. that is
number
the-
5.
Five. Five.
Mr. Chetia, you there? Mr. M. Chetia for? That's point number. Okay, hearing concluded, judgment reserved. Okay, now, with you, I think I have to dismiss your case. No, we have got to dismiss because you're not a party in the petition. So you want to withdraw, better? You want to withdraw this? And Mr. A. Cycle, counsel for the applicant, says that he may be allowed to withdraw the application as uh, he has not filed any application for impeachment in the petition. And as the matter has been reserved for judgment.
But one judgment which I have.
The prayer of the applicant's counsel is allowed. Writ petition, the application is dismissed as become. Acha, interim is there, acha. Now if they do anything, then we'll see.
No, the same judgment I have already made submission, only the copy I did not give, this is
Okay,
my copy, my lord, there is some marking, your lordship will pardon me for that, there is some marking.
I am going to get influenced. This will take some time. Next. 217. I don't have 217. I have only up till 200. Oh. Okay. Yes, you are appearing for whom?
I am appearing my lord for state bank.
State Bank. And you are appearing for?
I am appearing for ICICI Bank on behalf of MSF,
Where is he?
taking for another purpose.
He's legs. He's on legs. And did you contact the IFCI or what is that?
I am not
Who was
aware of
supposed to do it? 217. Yes.
Kindly report that one. That was Stonewall into five. After that. Okay. The curve. Other. Four nine. And I think focus on. Finish. 19. Never attended one voting, even the one prior to it. He has not received signature in any board meeting in any document pertaining to right under the bracket. What he does to the
So number 3 is the chairman.
yes, that's right, chair. But what he does, he writes to the bank. On 10th of July, he files suit. 11th July, he writes to this bank. Because he cannot express, he writes to the bank on the 11th July. Annex of 9, 20. But it doesn't disclose that there's a suit pending again. In the division.
Suit filed by you.
Yes, there was in the 98th would be decided that there would be a suit against man trying to trouble the society, and that suit was filed on the 30th September 25th meeting last 98. That is. Corporate part, once again, because it's the suit against it. And the suit was filed on the 30th September last. Thereafter, after the suit was filed, when he realized that he cannot exercise any control over society, he on the 7th, he right back, shut down these accounts. Portion, it doesn't shut down. There is no evidence here to cite that there is any that there is a deep fund against terrorism, or that there is any court order. He doesn't emphasize again. That also he doesn't. He doesn't think that he can find one thing prior to the letter dated 11th July. That also he doesn't expect. And what the bank does, he doesn't these two banks. IDPI reported us about. We placed all these facts in writing to. We were not afforded an opportunity by them. We have not violated any law. So that if this is a zero balance account, society is not. It is because society is functioning. It's working in the north and is just trying to put it by the structure. But the question that rankles in my mind is if this society run by the data of the leaders, put these best banks have all the chief to do this. That's what I ask. And they do it. Popular society is just working the
Who runs the account? Who can manage the account?
the
There must be one or two officers.
the account under the government.
And he's the chairman of the board.
He used to be the
No, but under how? How did you make that Gautam Mazumdar chairman?
in the earlier rule.
No, so there has been amendment of the rule. Has that been incorporated?
Yes.
And in with the registrar of societies?
That's every procedure. So then he fits below the bed. Writes to the bank, how is the concept? How he does one day after he files, doesn't even declare that he's filed.
I thought you filed the suit.
We filed, but yet no, September last.
And?
He writes this letter on the 11th of that this letter, but I don't say that for the number three writes.
He has not filed a suit.
He there's no signature by what?
No, has he filed a suit?
Yes. Number five.
Who-
Subordinate officer in his trial. Now he is the chairman. It became all the more easier. Pressurize this bank, stop this bank account. On the 27th, he joined, 27th of July, he joined CIPI as its CMD. The kind is an LFID,
What did you say? SIPI?
CIPI, Small Industrial Development Bank. Another key financial. IFCI is a key financial, they are sponsors. That was money meant for charity for being put in the north. They themselves speak on the board for the this is what it does. Profit of society can end, but in a day or two it is. At this. So they depend on the transfer. Those transfers are being, they are being utilized, run these projects.
Let me see the amendment of the rule.
41, it begins at page.
Of the writ petition.
Yes. This is so this. Like. This is that. Then.
No, where does it say the constitution or the appointment of the chairman?
That I say that given. Corporate part of the
232 to 239. Yes.
corporate part of there the portion and this cannot be validated. So under the earthquake, if the chairman is absent, meetings, the board meeting. Earthquake.
That's well ruled. What do you mean? That
The first one that was
amended when?
and
On 20.
meeting that- amended, right,
Where is that?
that 7 is
Page.
41. It's seven
No, this 232, 39.
would be
Where is that?
gave last paragraph. That's in the thing. Convene a negotiation. We can't. That's the.
Where is that? Where is that? Where is that? Which,
Wait,
yes, I've got which para? There's so many paras.
paragraph.
Yes.
Okay. So basically, the objective of the plan on the page. The same thing of fire. There are sites, but we need to get the benefit. The best thing in the fire, right? Of course, sites of sites with sites, it is. Cannot, it is not. But the IFCI cannot accept matter of us in the organization. Please. Like,
No, so this is a resolution. Where is the amendment made in the
that's absolutely, absolutely. Right?
so when the memorandum of association is amended, where is the amendment? I've got it, but where but regarding the chairman,
We tried uploading the operating thing. That's not there. Like, it has to be there for a format. Right. That's the. It makes it.
Huh?
It makes. I don't.
no, whether you have uploaded it or not, where is the amendment regarding the appointment of the chairman of the governing board?
That,
Where is it? Where are you reading, page? Clause 9, short description. That's all right. But how do you choose the chairman?
Here, single, banks, triangulate. One thing, I am, at 60, the society, the charters of the figures, they would think that
Oh, might be, but the problem is now, you see, there is no amendment to the memorandum of agreement. But then where is that? Where is the hard copy?
not. We, the return. That's why. And each problem
No, where is it?
that
No, again, that chairmanship.
I think
See, that was only a resolution was passed that EOGM will be called and then it will be decided. Now, where is that resolution with regard to that? And where is the where is the amendment of the
that was it. That was proposed by you. Right. You
yeah? No, this is the EOGM. Now this where is it?
have to be done by you.
Yes, where is that? Yes, where is that?
That
This 38.
happening.
Page 38.
Fine. Okay.
Yeah. Flipping from one page to the other. So I'm just,
Part of the earlier, it was done in 1990.
no, but where is that part regarding the chairman?
They did not attend the
No, not that. The appointment of the chairman as per the memorandum requires that he should be from IFCN. Now where is that rule that has been changed? That any other person can become a chairman.
that's not a fact. That's the fact.
So he's still the chairman. So that means
That's public transport.
then
That's like people. That's the conduct, the conduct of the plan.
no, but then at the end of the day, he's still the chairman. That means. For the time being, yes,
My lord, may I comment? I have no business with the money that is,
correct.
but my only thing is that, my lord, there are two truths what I have learned from my
There are two.
truth with
Ah.
running in between the parties.
Correct,
One, they are
correct.
plaintiff. One, I think perhaps the IFCI chairman is the plaintiff.
Ah.
So will that not be wise to file an IA for the lower court and get the order?
Yes.
Because, my lord, what the letter they have written, my lord may come to, because see, my lord, IFCI is one of the founding members of,
Which page are you? Which page?
this is the letter, my lord. They have annexed at page 242, my lord.
242. Oh yeah, I've got a meeting. After lunch or after? After lunch. After lunch. We'll fix it some other day. Very busy now today. Tomorrow also we've got a lot of meetings.
What is the time permit?
We've got that. No, we'll fix another matter too, no? Because what matter? Other matter is there.
And that particular he cannot that he cannot have public hospital.
Yes, why have you closed it? You
No,
should
we are
have.
not, nothing into business, my lord.
Yeah.
If the court grants an
Huh?
order, we'll answer it, no problem. We are, basically, my lord, what I have understood, that two fruits are pending. No, maybe, my lord, since there is a tussle between them, let them get an order. And if your lordship feels that no, unfreeze it, will unfreeze it. We have nothing to do with the money. We are just the custodian.
Custodial behaving in a manner.
No, not at all. My lord, the letter that has been written, my lord, no, my lord, unnecessary wrong level down. What?
No, but the problem is you are one person actually fighting. You are one organization fighting amongst yourselves. So that is the problem. Now who will operate the accounts? That's so no, supposing we defreeze it and tell that the issue of who should operate the account should be decided by the trial court.
That's true, my lord. By the time it gets decided,
No, for,
That expenses monitored by
oh, we can say that the day-to-day running of the society maybe, uh, maybe allowed. As monitored by the trial court, why should we take, we cannot monitor. This is not an issue between us.
that correct. But the only thing that the action of the bank, the third first writing to the bank. Third first writing to the bank in respect of somebody else.
Yeah, senior will be here. We'll do it after lunch. Get it.
We have held that the provision of Article 226(3) cannot be said to be directly, taking into account that it is a constitutional provision. However, we have given a purposive interpretation to the term makes an application and when it is received. We have given an interpretation that makes an application has to be an application for the judge or the judges whom the roster has been endorsed by the chief justice. And the date of 14 days shall be counted on the first date of listing before the bench.
Heard Mr. K. Chaudhary. Senior counsel assisted by Mr. S.P. Sharma. Learned counsel for the petitioner. Also heard Mr. P. Gogoi, learned counsel for the PWD. So, sir, the matter was heard at some length yesterday. As Mr. P. Gogoi, learned counsel for the PWD has submitted documents pertaining to the verification process conducted by the respondent in person to the documents submitted by the bidders, including the petitioner's tender document power. This court is of the view that the same should be submitted in the form of an affidavit. Accordingly, this matter on Tuesday,
I mean, just
Tuesday, by Friday, I will file by the Friday. Monday, they can certify.
one or 2 days may be given to us to file the reply.
Whether reply is required, I do not, what reply?
And these are all factual aspects we'll have to speak. 2 days time may be given for reply.
Will you file it by tomorrow? Friday?
Friday I will file.
Okay.
If they file it by Friday, then you file the reply by Monday.
Whatever it is.
Okay, so ठीक है.
List this matter on Tuesday. Mr. P. Roy shall submit his affidavit
21st, second.
annexing all the documents relied upon by him for disqualifying the petitioner's technical bid by Friday. That means 20,
I think
16.
listing will be on 20.
16, and any reply to be made
By
shall
Monday.
be filed by Monday.
Thank you.
This is the matter on.
20. And my lord, the interim direction will continue to take.
Interim order to continue till the next.
Leave them. But, a question that has fallen from this honorable court. Lordship, I come to page 263 of your lordship's brief. So there, IFCI respondent number 2 says he is no longer the chairman. Respondent number 3.
Item?
Yes, well, page 263. They have written to the petitioner society that he's no longer the chair. Because he has gone and
263.
joined elsewhere. Last page of today's action. This is to inform you that upon cessation of services of respondent number 3 as MD and CEO IFCI with July 27, his nomination on the board is hereby withdrawn by him. He is no longer functioning. The absence of any connection with terrorism, the funds being linked to terrorism.
Yes. Page 266. Have you got it?
Yes, Your Lordship, but that document has not been received by ICICI. What we have received, we have placed.
Anyway. So this is a document. Now, whatever be the case, since the issue pertains to the freezing of their accounts on, we see their account.
Lordship, let me direct.
What else is there? If there is any issue by any of the parties, they can always approach the state. But the problem is where it should notice. Have we issued notice?
Yes, Your Lordship. Your Lordship has issued notice on the very first day.
And now not even 1 month has passed.
Yes, sir.
Look, they are aware, well, look, this was filed on the 1st of this month. Today is the 13th. They have not filed their response. The only response they
No,
have
no, no,
filed
no,
is,
no, madam, not that. Notice was issued on 2nd August
my lord,
by this court.
my lord.
And notice was sent
On that day itself. Yep. Kago-
Notice was issued upon the respondent on
that
9
day itself.
August, 9 August. And today is
The 30th.
4 days.
At least still he files a response. This man who has acted against the interest of the society really finds a response. for them. At least the banks, my lord, they cannot take the umbrella of this man who has done this to the society, brought it down to its knees and trying to. Well,
It was this Mr. Manoj Mittal who has written the letter.
Yes, no,
Chirag-
Manoj Mittal, my lord, he
Chirag-
utilizes respondent
Chirag
number 5,
Sapra.
respondent number 4 and respondent number 5 to write these.
Who are they?
letters. My lord, one is a
Yeah.
executive director and one is a deputy general manager. His subordinates. He doesn't sign on any paper pertaining to the society. Not one signature, my lord, I'll place at the time of hearing. Not one signature of this man.
Only problem is, so that it's only on the basis of that, those 2 letters,
Yes.
correct? Where is that, those 2 letters, page?
Pages, my lord, I'll place. One is at pages 240 to 241. That is ICICI, letter to ICICI, and the other is pages 242 to 243. Those 2 letters. IDBI had a similar letter. They have not acted after receiving our response.
Issued by the respondent number 4.
Yes, my lord. Chirag Sapra.
Respondent number 5. Your
Respondent number 5, my lord, the deputy general manager, Chirag Sapra, author of this letter.
But the governing body still subsists.
Yes, Your
No,
Lord.
it's there. It is continues in perpetuity, my lord, in accordance with the earlier.
Okay, right. Heard Mr. B.J. Saruga, learned senior counsel for the petition. No. Heard Mr. S. Sharma, learned counsel for the petition. Petitioner society. Also heard Mr.
M. Sharma
For
for respondent number 6.
point number 6
7.
bracket 6 and 7.
Yes.
Bracket SBI,
No, ICICI.
ICICI Bank. So some also heard Mr.
Take it time.
A.K. Sahewala for respondent number
8.
8.
8 and 9. 8 and 9.
8 and 9, bracket SBI. Anybody else?
Union of India, my lord.
Yeah, earlier has submitted.
Okay, right, wait. Uh, Mr. P. Chakrabarti had appeared. Mr. K. Over, then CDC appeared for the corner number 1. Pushpa. What about Mr. M. Sharma?
I
Okay, you're for 6 and 7.
6 and 7.
No one appears for the respondent number 1, 8, 2, 3, 4, 5, and 8. No. 1, 8, 2, 3, 4, 5, and 8. As notices were issued to them only on 9, 8, 2020. This matter is being disposed of today as the presence does not seem to, as the present issue can be decided without the participation. The petitioner states that the account of the petitioner society in the ICICI and SBI has been frozen on the basis of
The letter dated 11th July
letter dated 11/7/2024 issued to them by the respondent number 5. On the ground that the governing board of the petitioner society had been illegally and unauthorizedly been reconstituted, besides illegally amending the memorandum of association without any right or authority. The same having not been recognized by the IFCI. IFCI,
Yes.
the complete, it could make it full. IFCI, what is the complete?
Industrial, erstwhile Industrial Financial
Industrial
Finance Corporation
Finance Corporation
of India.
of India, bracket IFCI. So what if I said that the last sentence? Then have not read by the IFCI, comma. The, no, just read from the beginning. Just read from the paragraph beginning. Read from, comma, besides, legally amending. Association, bracket MOA. As well as rules of the petitioner society, without any right or authority. So then, comma, the petitioner society should not be allowed to operate the bank accounts of the petitioner society. The petitioner's counsel submits that a similar letter had been sent not only to the ICI and SBI by the respondent number 5, but also to the
IDPI.
IDBI. However, while IDBI did not act upon the letter dated 11/7/2024, the ICICI Bank and the SBI have acted upon the letters dated 11/7/2024, issued by the respondent number 5. Even though bank accounts of customers can only be freezed if the customers are involved in any terrorist activity or on account of any court order.
Yes.
The next one, the petitioner's counsel submit that dated from here in the order dated 2/8/2024. Submit from submit side, we have to submit that. Wherever it is G, you make it G. Then next paragraph. The petitioner's counsel thus states that. No, petitioner's counsel submits that there are two civil suits
Yes.
pending.
Title suit number
605 of
Two civil
20
suits, that is title suit number
605 of 2023.
605 of 2023 pending before the court of.
The learned civil judge, senior division number 1, Kamrup M at Guwahati.
Everybody. And
And
no,
yes,
wait, filed by
the petitioner society.
filed by the petitioner side. The other civil suit is
PS number, my lord.
title
I'll give
suit
the
number,
number. I have stated that. I'll give the number.
title suit number dash pending in the court of
The civil judge, senior division number 1, same court.
before the same court.
Yes.
Filed by the
Respondent number 2.
respondent number 2.
The respondent number, my lord, not the IFCI. Yes. Respondent number 2. CS number, civil title suit number. I'll pay. 338 of 2024.
2 by 2, huh? That's 3,
338 of 2024.
2020. What is the issue? What is the prayer in both the civil title?
In the first suit, that he has no right to, that's the prayer.
To be the chairman,
Yes, no right to intermeddle in the,
affairs of the petitioner.
yes, my lord.
And he is not the chairman.
He is not the chairman.
Ah.
And he is, their suit, my lord, they say that the meeting dated 12/1/24, the governing board meeting dated 12/1/24 is null and void.
What is your title suit number is?
Ours is 605 of 2023,
And is
338 of 2024.
the issue is PS 605 of 2020. No, the issue is whether the respondent number
3.
respondent number 3 can continue as the chairman of the governing board of the petitioner society. While the issue in PS 68/2024
Is pertaining to the governing board meeting dated
is
12,
pertaining to the governing board meeting dated
dated 12/1/24
12/1/24. By which
by the governing body of the petitioner society, governing board of the petition.
the governing board has been reconstituted.
No, my lord, they have taken and step. Governing board was reconstituted in, on 7/11/2024.
Now, what is the prayer in that 58?
338, my lord, we could not annex because we just got a set of papers, a huge bunch. This morning.
Well, Lordship, there is a lots of dispute.
That will be decided in the suits. Well, that doesn't accord them the right unless there is even an allegation that the funds are being laundered. That there is.
No, I think we'll defreeze it, but then for taking out money, you go to the civil court.
Then, well, it dies its death, well, or money will be spent under the supervision of the learned court below. That may be there, but not to the extent that they defreeze it, well, then the meaning is lost. Unless they defreeze the accounts, well, the meaning is lost.
Court itself is under challenge before the title.
That will be decided there. That will be decided always, well, in the earlier
No,
MOU.
you see the thing is that who is the governing body, that is an issue.
Yes, ma'am.
Now, how can we allow you to, if we allow you to operate the account, then that would amount to recognizing you.
No, but kindly, Lordship comes to page 35 of your Lordship, please. The earlier MOA. Subject to these rules, page 35, clause 14, earlier MOA. Rules, regulations, bylaws, and the orders and directions of the governing board, executive director shall be responsible for proper administration of the society and for the conduct of the staff under the direction and control of the governing. But
Correct.
he still doesn't operate independently. It is under the governing board. If it is that board,
No,
what
but
is board?
the reconstitution of the governing board is under challenge.
that is no, my lord, that is not under challenge.
It is
They are
under challenge.
challenging a meeting of the GB dated 12/1/24, my lord. I'll obtain the instruction right away. Not the reconstitution. And my lord, kindly see the malafide.
no,
They have not disclosed that these suits are pending. When they write to these banks, they are silent. They're hitting the institution below the belt. They're not disclosing their position, my lord. This man did not disclose his position, including this institution, IFCI. When they wrote to the banks,
No, you see, because his letter
yes, madam.
says that there is a illegal and unauthorized reconstitution of the
Yes,
governing board.
that is a caution. After that, he says we caution. Well, whether on a caution, the question before this honorable court is that whether on a caution, on a mere caution, a third party's bank accounts, well, this is,
Anyway,
can be frozen.
you could not have frozen the account.
yes, my lord, that they cannot
That is
do.
one. The issue of who will operate that is a different.
That will be decided
Huh?
by the
If
suit.
they will operate, we have, if the honorable court.
We won't say who will operate.
That
We'll
means-
only say that it should be.
Basically,
This court is not going to say that the petitioner should operate.
Yes,
Or
my lord,
anyone.
they
We
will
are
be
just going
free.
to say that it should be DP.
Yes, my lord,
And the person who is authorized to operate
shall operate.
as per the
Extent rules of the society.
as per the extent rule should operate.
Very well. Very well.
We won't go beyond that.
then again, your lordship, we have to verify each and
No,
every.
my lord,
You
that
have to,
is-
you,
they
that
have
is up
taken a
to you.
step.
I do not know.
That
you-
they will have to,
that you take a decision on that.
yes, my lord, they can do things with their own muscle power, they'll.
No,
still do
just
it.
a minute. Man. So you see, the thing is that you have freezed the account, which you should not have. Correct? Can you freeze the account in this manner?
Your lordship, that is very clear, that the governing body has to appoint the director at least at least number 35.
No.
Executive director shall be
Just a minute,
responsible.
madam.
My lord.
Your lordship, page number 33.
Yes.
That is the chairman.
Huh?
That is a nominee of the IFCI shall be the ex officio chairman of the governing body of the society. Then thereafter, your lordship has finally come to clause page number 36, that is the banker.
That is the
Banker.
banker.
The banker of the society shall be appointed by the governing body.
Correct.
And if then all the funds of the society shall be credited into the society's account. One or more of the state bankers and shall not be withdrawn except by the check signed by the officer empowered in his behalf by the government. If the governing body is correct, we have no issue. But if the governing body itself is under the question, then your lordship, we are under the fiduciary relationship. Then we have to release the fund, then the fund itself will be questioned tomorrow. Then the entire onus is on our shoulder that why we have dispersed the wrongful exit of the fund. That is why I am only, that the letter itself is being fulfilled.
But that submission, it is not backed by
And
law.
your lordship, I am the operator of my account and I can give directions to my bank. So they are the operator of their account. If they are rightful, we have to obey their instructions. We are not there to disobey their instructions.
We treat it.
So the operation of the, let it be done by the self.
Yes, sir. What is my public? Let them
Will
file.
will decrease the account that the operation be done on the basis of the decision of the self.
But by then,
Or else
cease
your
to
lordship may
exist.
direct us. Huh?
By then it will cease to exist because.
No, but then the,
Use.
but then the problem is right now, that is the problem. The issue is whether you are the governing board or not. We
But
don't know.
That will be decided in the trial court.
Yeah, that's
That will
what-
be decided in the trial court.
Right,
But
we follow
what
now
the banks
the
have done, my lord, it puts even an ordinary man at peril, a third person, whatever it may be, unless there's a court order restraining them, unless under section 45 ZP of the Banking Regulation Act, unless the funds are linked to terrorism, or there's an allegation even, there's no whisper that the funds are linked to money laundering.
No, the problem is whether you are the governing board or not, that is the issue.
Governing board cannot operate the accounts, my lord.
No, but the governing board is the one
He is
who
already
will appoint the
authorized.
banker.
Yes, my lord. He is
So,
authorized.
so you see, the banker has to be appointed by the
Well,
legitimate.
they are the bankers. They were appointed. They were appointed as bankers. Well,
And
they
your
cannot touch an individual's account unless these.
But
three-
only the correct governing board
Yes.
or the legitimate governing board
My lord.
can operate the account.
No, governing board cannot operate the account.
Then who will operate?
It is the executive director who is ultimately responsible.
Where is that?
That is in original MOA, my lord. Page 35, clause 14.
And has that original MOA been amended?
Yes, my lord.
And has that clause been amended?
That, my lord, I'll play it.
Huh?
And your lordship, is number 224, 225. It's still under the construction, your lord. It is not finalized.
No, no, no. I'll
It's
play.
number 224, even the.
No. This is not the,
name
this
of
is not.
Name of the
This is
RGBN.
the draft thing which could not be uploaded.
Kindly count it, page number 220. It is in draft copy.
No, no, this is the draft, my lord. This is the draft. We couldn't upload it. What we have uploaded is at page.
Your lordship may kindly see from the very
No,
first
no.
line.
I mean,
And
original, page
225,
41, my lord.
It is formatted somewhere written like that,
No.
under the correct mode.
No. My lord, this is at page 41.
224.
For your lordship,
That is,
RGBN name has been slashed and thereafter in bracket.
no, my
RGBN.
lord, that we could not upload.
And
They
thereafter
wanted-
page number
we are not
225,
relying
your
on that.
lordship. And again 225, your lordship, that is complete right hand side. It is still under format.
No, my lord, that we could not upload. When we
Okay.
placed before the registrar of
believe on
societies. No, my lord, what we have uploaded before the registrar of societies, it is before this honorable court, my lord, page 41. It begins at page 41.
I think we'll wait for 30 days at least. Let them appear.
Let them appear.
If they don't
But
come,
I am,
then we'll decide. Let them-
They
30
succeed,
days.
my lord, this man who has left IFCI today, who is no longer
No,
in the
we'll decrease the account, but we will say that no one should operate it for the time.
same position, my lord. Salaries, my lord, kindly see the monthly requirements of the institution today, my lord.
Where is that?
Well, that
asked you to
appears
make
at
a-
page.
I
well,
asked you
what
to
is-
make a affidavit.
I will paste. I have brought it on act. Full page,
your lordship 245.
245, my lord. Two hundred and 23 employees, my lord. Salary is about 44 lakhs. of theirs and the rest,
It is, monthly expense is 1 crore
1
44
crore,
lakhs.
yes, my lord.
And salary is 47.
But salary is about,
Rent, electricity is. this much.
electricity is about 2,69,000.
So you need approximately around 51 lakhs
Yes,
in a month.
yes.
So let them operate for the payment of this. But I think let them go to the trial court and inform the court regarding this. This is. We'll send it to the trial court, let the trial court decide as to the exact amount is required. And let them pass an order to allow you to take out the money.
And if required, within the
Monthly.
time bound.
That will, my lord, that will again take months, my lord.
Why?
Let us even forget the salaries, my lord. These projects will be on hold. These
Projects
are all
will-
projects run by corporate houses, my lord. They are the funders today. ITC is there, my lord. Imperial Tobacco Company, my lord. LIC is there, my lord.
No, you see, just waiting for another 30 days, I won't fall. The problem is where we should notice. Where we should notice and deciding this case, we should notice and without waiting for them will not do.
Protection, my lord. That what they have done, my lord, on the face of it is arbitrary.
You have not given wages till when?
Beg your lord.
Wages till which period?
Wages,
which
my lord, this is a monthly requirement.
Yes, but you have paid wages till which date?
That, my lord,
For which month have you paid wages?
last month they could, but from day after tomorrow, my lord, the organization. will
So
get
you have paid wages till July.
Yeah,
Where have you said that?
that I have not stated, but that's my instruction. This is the monthly requirement. No, I'm not misleading.
No, I know, but then I'm saying you have paid wages till July.
Yes, sir.
And for August, you don't have money over.
No, but no,
Where is that? Where is that?
that,
For-
there's not a clear averment, but that is the position, my lord. We'll not be able to pay the electricity bills, the rent, everything will come to us then.
No, you have to be a very
Precise.
clear, precise averment that we do not have any money because you have got another account.
Yeah.
You have got that IDBI account.
Yes.
And how much money is there?
But I cannot say. I'll,
You give me a precise amount.
Yeah.
How much money you have got there? How much money in hand? How much you are going to spend? And that you don't have any money besides this, then we will allow you that. And then we will wait for 30 days. Because unless that 30 days period is over, we cannot say that the respondents are deemed to be served.
true, my lord. Here, my lord, the allegations are against the action of the bank.
Maybe, but then there are other
The
things that
third
have cropped
person,
up.
my lord, approaching the bank.
No, but
Someone says, my lord, says that my accounts are bad. I am the mighty state. Someone comes and says that I am the mighty state under Article 12 and says her accounts are bad with the bank. Well, the bank freezes my account, my lord. Where do I go?
no, you see, it's not so simple. If I pass an audit tomorrow, they will go to PB. It's not
Beg your
simple.
lordship, but,
Supposing I pass an order today,
my lord,
which doesn't take into consideration all the other factors. Then tomorrow they are going to go to the division bench and my order is going to be stayed.
that is always there.
So I have got to also be careful that I am passing a reasoned order.
Very well, my lord. But the main question before the honorable court is
May-
the
may-
banks.
But then there are other considerations also because you have come in a writ.
Yeah.
I can always, expand my
Yes, my lord. That is always,
jurisdiction.
that is always there.
So
that
that
I-
is why I have to be careful. I've got to see what is behind everything.
Very well.
Only, so you come with a precise number.
Yes.
With regard to IDBI bank, how much money you have got
Yes,
there,
my lord.
how much salary you have paid, and that
What is the
you are
balance
running,
there?
yes, your statement of account with IDBI, and then amount of salary with particulars as to how much is
all
to
the
pay.
bank
Oh,
accounts, my lord.
yes, all those persons under your employee who are to be paid, and that they have to be given salary for this month. Your water bill, electricity bill, you come with that. Okay.
I will. Lordship takes it up on Friday, subject to the condition.
Friday, I won't be here.
Monday,
There are a lot of cases. Monday, Tuesday, a lot of. Wednesday. Where are we? Like, just, no. Is whether the respondent number 3 is the chairman of the governing board. And, uh, and the issue in WPC, in TSP 3.224 is the challenge made to the
meeting,
composition meeting,
meeting held
the
on,
resolution
board
passed in
meeting held on
Resol-
12/1/24.
board meeting held on 12/1/20. Governing board meeting held on 12/1/20. A perusal of the documents brought on record does not indicate that the memorandum of association, which is sought to be amended, has been accepted as such by the registrar of society.
It was,
But where is that?
well, at that page 41, that's the stamp and the seal,
One.
certified to be true copy, registrar. of
Okay, okay. No. What have I said? A perusal of the documents does not indicate that there has been any amendment of that first clause. Where is that? There's any amendment with regard to
Pages 25 to 30.
who should, with regard to the chairmanship of the governing body being held by an employee of IFCI. That is not there. They're not amended.
That's the last fail in the public ballot. We couldn't upload that. We couldn't upload that MOA.
No, it has to be accepted, no?
Yes, Registrar of Societies has accepted this document.
Where is that accepted? Where is that?
That's certified to be true copy, my lord. That is the MOA. Page 41 of your lordship's brief.
No, but where is that provision which says that the governing body, the chairman of the governing body shall be this, or something like that?
This does not say, but my lord, the decision was taken in the EOGM that the sponsors wouldn't be there.
Where is that?
EOGM, my lord, appears at page. Yes.
Ah, anyway, whatever I said, cut that last point, cut the last sentence. That's right. The petitioner's counsel has also referred to letter number IFCI/SACD /RGVN/2024 -240802028 dated 2/8/2024. Where is? The nomination of the respondent number 3 as MD and CEO of IFCI with effect from July 27, 2024. His nomination on the Board of Governors of the Petitioner Society was withdrawn by IFCI with effect from 27/7/2024. Next. The counsel for the respondent bank submit that they had freezed the account solely due to the letter dated 11/7/2024 issued by the respondent number 5. Respondent number 5. And not due to any other reason. A prima facie reason, on considering the issue at hand, this was fine. Prima facie finds that the respondent bank has not, has freezed the petitioner's account only on the basis of a letter written by the IFCI and not due to the relevant clauses of the RBI Master Circular or Section 51 bracket A of the UAPA 1967. Good, sir. The next paragraph. The respondent, the counsel for the respondent bank shall specifically obtain instructions with regard to whether a customer's account in their bank can be freezed without following the relevant clauses of the
RBI circular
RBI Master Circular
on
and
and section
Section
45.
51 bracket A of the UAPA Act 1967. What's the further? No, that's all. That's all. Because there's no court order that.
Yes.
As far as the market concerned,
No, I'm not on your objection with the money. I'm on the question of whether you can freeze a customer's account
Yes.
on the basis of a letter written by a party and whether you can freeze the account on the basis of a letter written by a person.
individual, it's the government. FCI is under government of India.
No, but where is the power? No.
Kamta,
So supposing the chief minister writes to you, please freeze this on the account, you freeze it.
but he should have some relation.
Or supposing a peon writes to you, he's a government servant. Peon writes to you that you freeze this account. Because he's a government servant, you freeze it. No, Mr. Counsel, please.
There must be some relations.
No, relationship is what? If this person has got, you see, this has got no relationship. For the simple reason, they might have one of their employees as the chairman of the governing body of the
As per clause.
society. But they don't have relationship otherwise. They might be a benefactor, they might be giving the money and or whatever.
Letter he has made some previous allegations.
Mr. Khan, that is not
Taken
your,
over
that is
of
not
the-
your problem. No, just a minute, madam. Yeah. So where is the question? Why should you just freeze? Why should you just freeze the account? Just tell me a reason.
Because of
Can
the
only can so you can freeze if anybody writes a letter to you.
No, not anybody.
Who can?
We are not there to.
No, tell me.
entertain Anybody.
Tell me under what provision can a bank account be frozen?
We will predict.
When?
If you are not on the very next day.
Okay, right. The respondent's counsel shall produce on the next day the various instances under which a bank account can be frozen. A customer's bank account can be frozen. The various instances I said, Various-
We have only
Till
frozen the
then-
debit.
Huh?
We have only frozen the debit,
Well,
card, not the
till-
credit.
Till
Naturally, you don't want to give.
No,
This is
technically,
protected.
we don't want to get into mess. Otherwise, somebody will come up and silence.
No, I only want to know. I'm not interested about your credit part.
We have faced that.
No.
Just right. The counsel for the respondent bank shall specifically obtain instructions as to on what grounds a bank can freeze a customer's account for withdrawal of money. I'm not about deposit, I'm about withdrawal.
That is an offense under.
No,
the NIA.
let him list the matter on 21st.
Till then I may be protected.
Huh? 21st.
Well,
Ah.
let them produce, Malab. Till then I may be protected.
Produce what?
Produce these instructions because Malab, what they have done is an offense under the
No,
NI.
no. They didn't bring that. In the
Because they
meantime, you
don't
can make your
allow it,
application.
Malab.
In the meantime, the
They should-
petitioner's counsel may submit, may file, may make a affidavit stating the monthly requirement for giving the salary of the staff and
The projects that are run.
not projects and okay, projects also.
Yes, Malab.
The monthly requirements of the petitioner. What is the IA?
Oh, Malab, there's an IA. Malab, this is for correction of the typographical mistakes at pages 5, 18, and 20. Malab.
Okay, right. First, Ms. M. Sharma, the counsel for the applicant, who feels that she may be allowed to make correction of the typographical errors appearing at pages 5, 18, and 20 of the writ petition. The prayer of the petition applicant's counsel is allowed. The applicant application accordingly disposed of.
He feels like.
The corrected copy of the page 5, 18, and 20 may be submitted by the applicant to the registry within
Tomorrow.
2 days,
He feels.
3 days. Ah, yes,
Maybe the lot. Lordship may kindly take up the item number 20, madam. Application number 406.
yes. What is your case?
Madam, they
They
have
are asking you to pay the EPF
EPI, madam, on the gross amount. not
gross
on the-
amount,
Not on the basic.
but you are supposed to pay on the basis.
Basic, madam, as per the financial bit, which I have.
Sure.
Lordship will find at page 39, madam. Annexure 5.
Page 39.
Yes, madam. This was my financial bit, madam, which I have submitted.
Yes, yes.
The minimum wages is 13122. Basic is 4539. Then the doctor will come down, madam. EPF is 1102. Now the dispute is regarding the EPF, madam. They have directed me to deposit the EPF on the gross amount, not on the basic.
Where is that?
Yes, madam. Notice will come at page 48. This is a letter issued by them in response to my representation, madam, on the earlier case. Now, paragraph number 5, madam. There, as per the wages statement submitted by your firm, so and so, EPF is computed and deposited on rupees 4885 instead of rupees 13958, which is not as per the amount. The breakup of the wages submitted by so and so are as so and so.
So according to you, you should pay as per basic. You should pay as per the act or the rule.
Yes.
What does the act or rules provide?
Rules says, madam, rules says, not we have come to the next page, madam, page 51. This is the Employees Provident Fund scheme. Here, 29 contribution, subclause 3.
Huh?
Yes, madam, subclause 3. The contribution shall be calculated on the basis of basic wages, dearness allowance, including the cash value of any food concession.
Training allowance, even.
Madam.
The basic wages and dearness allowance is there.
Yes, sir. But my lord, when I submitted my financial bit,
No, yeah, it does not matter when the statutory, what is it? It's part of the rules or what is it?
this is the act, madam.
Act. So when the act requires you to pay the EPF in a certain manner, by calculating in a certain manner. That cannot be violated unless you make a challenge to this act.
But if your lordship allow me to show the MOU, the memorandum of understanding, that is at page 43, annexure 9,
Page 43 and Annexure 9.
annexure 9. my lord.
You see, any agreement made in violation of the act, made in violation of any statutory law,
That
is that?
that can be adjustable.
Then?
Will be paid, my lord.
what happens?
That demand which they have made. my lord, If your lordship come at page 45,
Page 45,
my lord,
yes,
45, clause 13,
clause 13, yes.
that was read as this MOU may only be amended, modified, or supplemented by an MOU in writing, signed by each party.
So what is here? What do you show me here?
Yes, my lord. Any of the terms herein may be waived only by a written document signed by the parties. Now, my lord, question is, my lord, without changing the MOU, without amending the MOU, this they cannot demand.
They cannot demand.
Yes, my lord, that's your own MOU.
No. If an agreement made between two parties is in violation of the law, then what happens? The agreement will supersede the law.
No, what? No, my lord.
Supposing you make an agreement
Yes, my lord.
to murder someone,
Then I agree.
will it make the agreement valid?
That I agree, my lord. But that MOU has to be amended, my lord, at least.
How will it be amended? But then you have got to pay your EPF.
We have paid, my lord. Even then, after paying
No,
the,
you have to pay as per basic wages, generous allowance, including cash. It has to be done.
we'll pay, my lord. But now that question is,
Page 44 is clear. sir.
It's
The
44.
MOU also includes that government meter notification.
yes.
Where does it
Page
say?
44, meter.
There are
Yes.
three, my lord.
Para 3.
Yes.
Here it-
There are three.
Yes.
The wages of the security guard shall be as per the quoted rates of party B and wages defined in the government of Assam notification to and so, dated to and so, must be followed, including prevailing rules for ESI, EPF, etc. So that EPF rules should be
Has to follow.
Sure.
You cannot violate the rule.
Yes,
If an agreement is made between two persons in violation of the rule, the rules will have to prevail. The agreement cannot prevail. So what do you want out here?
not my prayer, my lord. Now what they have done, my lord, annexure, my lord, 15, my lord, page 152. They have terminated my contract, my lord, without issuing any notice,
That's a different issue, isn't it?
my lord. Page 152, last,
Huh?
my lord. Annexure 15.
152.
They have terminated my contract, my lord.
Clause 3.
Without issuing any notice, my lord.
Yes.
Sir, earlier that communication has been made.
Where is the notice?
Lord, kindly turn to page 48. The last 3 lines.
Yes.
I'll skip the other paragraph. In view of above, you are hereby asked to take the necessary steps to deposit all the amounts as per rule and agreement and inform the undersigned within 7 days from the date of issue of this letter. Otherwise, necessary action will be taken as per rule and agreement. Thereafter, my lord, say respondent, my lord, next page.
My lord, this letter, if you
After that, my lord,
at reference, you know, in reference to my letter, my lord, which is not a notice, my lord, as stipulated in the MOU.
After saying all he wants, now he's asking you.
Right, you want to say, my lord?
Yes.
He's the senior, my lord.
Lord, page 48, my lord, communication, my lord, and in response to that communication, my lord, page 49.
Yes.
They have responded, my lord, within 4 days, my lord, on 22/7/2024. And thereafter, my lord, after 1 week, my lord, this incident letter has been by the end of John. Last page, page 1.
Page 150.
No, last 150.
But then this is not a notice. No notice has been issued by you.
My lord, since, my lord, necessary action will be taken as per rule and agreement.
No, but then naturally everything has to be done as per law. Whether do you terminate someone's agreement or contract or service, it has to be done as per law,
My lord,
as per rules and conditions and agreements. But then The fact remains that you have got to issue a notice.
Sir, that is why, my lord, kindly turn to page 45, the
Page
termination
45.
of agreement.
Page 45. Yes, yes,
Clause 15.
yes.
Agreement can be terminated by the first party with prior notice of 1 month in case of unsatisfactory service.
Where is the
addition of-
prior notice of 1 month?
My lord, that page 152 is clear. May I
Page 150?
do the last impugn letter?
Yes.
In inviting reference to the subject cited above, the last page,
Yes, yes, yes.
I am directed to inform you that the university has decided to cease the business services with your agency due to violating of clause 2 of MOU dated 20. Therefore, it is important. As per clause 15 of the MOU, the university terminates your services with effect from 31/8/2024. 1 month, my lord. It was issued on 1/8/2024 and termination will be
Achha, where
effective
is
from
this,
31.
where is this MOU? Page?
Page 45. The last clause 15. Technically, my lord, that 1 month period, sir, it was issued on 1st August and the termination will be effective from 31 August. So 1 month.
No, no, but then at the end, you have to give him some time to give his side of the story.
That is why, my lord, 1 month time has been given. It has not been given effect to, my lord.
No, 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 you have terminated him without giving him a chance to make any reply.
My lord, that communication amounts to, my lord, that notice, my lord, prior notice, my lord. 1 month, my lord.
That is,
And it is total violation of the EPF rules and schemes.
yes, you have not
Total
paid.
violation of the MOU. And
But without conducting an inquiry in the meat of the contract, how can my lord, they terminate my lord?
Well, the facts very clearly show that he has not paid as per the rules and as per the agreement.
Yes, and what is
It is clear as daylight, a daylight robbery in fact. You are not giving the EPF.
We have
2 years.
already submitted my lord, as per their demand. They already submitted my lord,
What, submitted what?
submitted the bill. Bills are supposed to be submitted every month by depositing this contributions, my lord. That we have,
Show me where have you, where is your bill? Show me your bill.
the bills I have not annexed, but he can take the answer, my lord. I have submitted the bills
Huh?
as per their demand, my lord.
Where is that? Where have you
I have
taken?
not annexed.
Where have you stated in your affidavit?
My lord, my lord, that-
the bill has not been annexed, my lord.
No, we are not.
Within that 1 month period, they may still, my lord, respond, still, my lord, go without the representation to the vice
Yes, sir,
or
yes,
still they have the opportunity.
Yes, sir.
Ah, you still got that August is not finished.
Not finished, my lord.
Then
Not finished.
you comply with the order.
Yes, sir. Yes, sir.
You comply with the order. You give it as per the rule,
Confirmation.
and you consider it. Sir.
My lord, they may file, my lord, representation before the authority.
Yes, and with complying with all the EPF regulations and rules. Okay. Right. Heard, Mr.
SP does not.
SP Das, Senate Counsel for the petitioner. Who submit that the petitioner has been providing security guard services to the respondent after signing a memorandum of understanding dated 1/3/2024. The petitioner is aggrieved by the action of the respondent authorities in terminating his security guard service by the impugned order dated 1/8, impugned letter, impugned termination notice dated 1/8/2024, issued by the respondent number,
Register of
issued by the respondent number 4. Which is to the following effect, page 150. Next para. The petitioner's case is that the respondent authorities have directed the petitioner by the impugned letter dated 17/7/2024 to deposit the employees' provident fund bracket EPF as per the notification dated, where is that?
Earlier it was issued on 17/7/2024.
The latest one?
Okay.
It's 48th number.
Page 48.
As per the notification dated 17/7/24 issued by the respondent number four, five. The petitioner's counsel submits that the petitioner has been directed to deposit the EPF on the gross monthly pay of the gross monthly pay of the security guards instead of the basic pay, in violation of the MOU dated 1/3/2024 and the Employees Provident Fund Scheme 90. He further submits that no notice had been issued to the petitioner prior to the issuance of the termination notice dated 1/8/2024, which is to take effect from 1/9/2020. Next, Mr.
TJ Fukan, my lord.
P.J. Phukan, the learned counsel for the
Respondent 1, 3, 4, and 5.
point 1, 3, 4, and 5.
The university.
Huh?
The university.
That is the university. Submit that in terms of
MOU.
clause 3 of the MOU dated
1/3/2020.
1/3/2024, the wages of the security guard are to be paid as per the quoted rate of party B, of the petitioner, and wages defined in the Government of Assam notification number E-262-184/16 dated 3/2/24, including the prevailing rules for payment of ESI, EPF, etc. Further, in the event of any update of the Government of Assam notification regarding wages for employees of the private security firm, the same was to be followed. He submits that that in terms of para 50 of the MOU, an agreement can be terminated by the first party with prior notice of 1 month in case of unsatisfactory service / violation of the terms and conditions of the agreement.
There are 13 of them.
Huh?
There are 13. They now has to be in 16, madam.
It's not my submission, my lord.
How does this help? This is,
Anything has to be changed.
Huh?
If anything has to be changed, that has to be in written, madam.
I'm not on that.
Amendment, my lord.
Mr. Counsel, that is not an issue. The issue is when you pay your EPF You have got to pay it as per the rules and the act. Then that's all. There's nothing beyond that. Where's the question of amending the MOU? MOU is nothing. You have got to follow the act and the rules. That's all.
Page 51. Right here, page 51.
So subject, sir. The Mr. PJ Fukan, Learned Council for the university further submit that the
EPF scheme of 1952, page 51.
the EPF scheme of
1952.
1952,
Clause 29, subclause 3. Page 51.
in terms of clause 29 bracket C, requires that contribution for payment of EPF has to be calculated on the basis of basic wages, dearness allowance, bracket, including the cash value of any food concession, bracket close, and retaining allowance, bracket, if any, actually drawn during the whole month, whether paid on daily, weekly, fortnightly or monthly basis. Page 51. We submit that the stand of the petitioner, that the EPF
Because page
of the
38.
security guard cannot be calculated only on the basis of the basic wages of the security guard. But in terms of the what scheme?
EPF
The EPF scheme of 1951, 52, read with the statutory act and rule. Next. Next, Mr. PJ Fukan further submit that the 1 month notice period,
prior to that, page 48.
page 48,
Page 48 is followed by page 150.
he submits that as the petitioner has not violated the memorandum of understanding read with the letter dated 17/7/2024 issued by the registrar by the point number 4,
Five.
there was no there was no violation. No, there was no infirmity with the termination notice dated 1/8/2020 issued by the respondent number 5.
Question number 4. Page 40 was issued by respondent 5 and page 152 has been issued by respondent 4.
48 is also by
Deputy registrar, not registrar.
okay. Oh, you got it, huh? Yeah, same thing basically.
Almost same. Concern respondent.
Okay, right. Mr. PJ Fukan submits that. No, however, submits that as the notice period of 1 month has not expired as on date, the petitioner can maybe the petitioner can try for a course correction of his try for a course correction of his
Bill submission.
misdeed. No,
Bill submission of bill.
course correction with regard to submission of the EPF bill of the security guard by submitting by calculating the EPF amount in terms of the EPF scheme of 1952 and by submission of a representation to the universe to the respondent number 5. He submits that in the event the petitioner submits the EPF to be paid with regard to his security guard in terms of the EPF scheme of 1952 and the relevant rule, comma, the, and along with the representation which may be submitted within this month. The respondent, the respondent university shall examine the case of the petition for continuing his engagement as per the memorandum of understanding dated
1/3/2026.
1/3/2024. When is the expiry period?
1 year. 1 year.
Okay, 1
will be
year.
extended for 2 years.
Oh, good, sir. The, the petitioner also submits that he does not have any, he does not have any, quarrel with the proposal made by the council for the university and submits that he will deposit the required EPF of the security guard in terms of the scheme of 1951, 52. And submit the receipt of the same along with a representation to the respondent authority that he has complied with the request made by the respondent authorities in terms of page 48, in terms of the letter dated 17/7/2024 issued by the respondent number 5. In view of the submissions made by the council for the parties, this court is of the view that as and when the petitioner submits his application along with the copies of the receipt of submission of the APF of the security guard in terms of the scheme of 1952, which should be done not later than which day? Today is what day?
Within one.
Oh, no, some more time we need to collect money. Within by 27, 8/2020 4, comma. The respondent number 5, respondent university to take a decision on the same. Full stop. Till a decision is taken by the respondent with regard to the petitioner's representation for setting aside the impugned termination notice dated 1/8/2024, comma. The impugned termination notice should not be given effect. Full stop. The above is of course subject to the condition that the petitioner submits his representation
Prior to 20.
on or before 27
Eight.
8/2020.
My last prayer, madam, one more prayer. In the meantime, they will not go for test tendering, madam. They are contemplating to do so, madam.
Lord, I have received instructions, Lord.
Yeah,
Already, Lord, tender document has been processed.
That's right. At this stage, it has been submitted by Mr. PJ Fukan that tender documents have been published by the university for engaging security guard separate. And this court is of the view that
Outcome of
that the NIT issued by the university for engaging fresh security guard should be kept in abeyance till a decision is taken by the respondent authorities in respect of the representation to be submitted by the petition. The writ petitions accordingly disposed. Huh? What is it?
Same, earlier it was, it has become infrastructure.
This is infractors. One is infractors. So we dispose it of infractors. Which one is it?
19.
19 infractors. Okay, right. Mr. PJ Saike, learned counsel for the PJ and Mr. SP Das, learned counsel for the petition, submits that the writ petition has become infractive in view of the filing of the subsequent WPC number 4027 of 2024 by the petitioner.
Submission letter.
Mr. PJ Fukan appears for the university. And in view of the submission made by the counsel for the petitioner, the writ petition is dismissed as infractive.
So the second one. is disposed of the-
The second one has been disposed of. 19 is infracted. 20 is disposed of. Actually, in 19, what was the challenge?
My challenge was regarding the non-payment of bill. In the they have targeted, madam.
Not payment of bill.
They have scope of bill, madam.
It's against that, deferred, bill 48. Second one, against that. Bill 150.
So that he has said that he will pay. So he will pay, he said, so that will become infracted in a way. Because he has now taken a stand that he will pay as per the 1952 scheme. So that he has withdrawn basically, You could have said you withdraw, it's better withdraw. Okay, right, just say, Mr. SP, Das, then pass it for the petition subject, that in view of the filing of the subsequent writ petition, that is WPC 4027 of 2024, he may be allowed to withdraw. WPC, he may be allowed to withdraw the writ petition. Mr. PJ Fukan appears for the university. The prayer of the petition counsel is allowed. The writ petition is dismissed and withdrawn.
I think so.
I don't think that would be possible for the time being.
Item 11,
Time being.
19,
Time
Nine-
being.
time being.
So, let me one fact. This case was, I for the management. So they have challenged the award for the industrial development. What about the worker who had challenged, the case has been filed as a representative capacity, under representative capacity as per section 36 of the IT Act. So now we have come across one letter sent by the worker himself, saying that he is no longer interested. His letter dates to 2016 month. This case was pending for too long, Malad.
2014, my God.
Yeah, 14 matter, but this letter, Malad, I'm instructed to submit before your lordship, but it's in vernacular, Malad. It
Okay,
says,
he'll read it.
it says he is no longer interested to conduct the case. Somebody has filed the case without his knowledge, Malad, something like that. So if my lord instruct me, I can, Malad, bring the original one.
Bring the original what?
Of the letter.
This is the original, this is not the original.
Xerox copy.
It's okay. You can, why don't you translate and submit?
That I can do, Malad. My lord will direct, I will do that.
No, anyway, where is your senior?
Here is the port number 7. Electric port.
Who is the senior?
Ashish Das Gupta.
Huh?
Ashish Das Gupta.
A. Das Gupta, senior counsel. He's not interested in pursuing this matter.
So far, this letter is concerned, it says so. Or we can take instructions.
That's not there. You give him this copy,
Yeah, I'll do,
better.
Yes.
And let him, okay.
that I,
This is what dated?
this is of 2016
Date.
date. So, date is there.
You call a senior, let the senior read it. The senior might want to make some submission. Let's wait.
May I speak to Lordship?
Let's wait. Let the senior come.
Lordship, the conducting counsel, Mr. KP Pathak, is in court number 70.
Mister?
KP Pathak. For APT.
What to do then? I think. Mr. Saib, I can ask whether I am reading about it. But he's not here.
Okay. 17.
What to do? We'll adjourn the matter. It's not here. No point. Right, Mr. James Avala appears for the. Look, on the last court date, you were on the legs in another court. So you have to give some understanding. Mr. James Avala, learned senior counsel, appears for the petitioner. However, as Mr. KP Pathak, the learned counsel for the respondent, is on legs in another court, matter adjourned for 2 weeks. This is the matter.
Prepare a short written note also, my lord.
Huh?
I prepare a short written note also, so that it can be.
What to do?
My lord, in 16, my lord, I have filed one I8. Implement of
15 and 16. Huh?
I8, my lord, is not numbered, but
It's not numbered, then it cannot be listed.
his filing number is here.
No, 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 no. Then it will not do. No?
That can very difficult to tell him.
What is that for?
And okay, implement of the kind of altogether 140 kind of workers. We are kind of a member of the association, that is respond number 4. Because we don't want to contest the case because some new development has occurred during the pendency of the case. So one MOA has been signed between the management.
100 and page, you mean item 15?
15 months, so I'm 60. 15 is the other.
Mr. Goswami, are you here? Are you in 16? 15, 16?
Yes,
Is it the matter that I heard? No.
yes, yes. Lordship,
I heard that
yeah, yeah.
Yeah.
Lordship,
I had made some note, I think.
yeah,
in that
your
meeting.
lordship
Hey,
dictated.
where is that note I made? No, no, I took it home. I thought I'll correct it. I forgot about it. So busy.
Your lordship dictated here.
Yeah, it's in the computer, I think. Get me a copy. Huh?
Yeah.
Two 2020. Now, what do you want?
But we don't want to contest the case because the association, our association, and they are not accepting the MOA. So, but we are interested to accept the MOA because the matter is still long, it is in pending, and it will run for another year. So, by this time, many kind of association members are retired. So, we'll be also retiring. So, I am not getting any benefit. The MOA, if I know they accepted, then some benefit will get. Management and the workers union, another workers there on the MOA has been signed. We are ready to accept the MOA. And this is what the benefit.
But your application is not here. When did you file?
It is filed by the day before yesterday.
Only filing number is there.
There is only filing number.
And that cannot be listed. We cannot even call for it.
It was come along with this. I am on Monday, but
Monday, no, Monday, Tuesday, where?
then Friday,
Friday is holiday. I am going off.
Friday. Sorry. Then when of the next at least
We can try. We can try. Huh? We can try. We can try. Mr. Das. Mr. Das. Now, he is there in item 16. You're 16. No, no, that's we are on, he's on 16. He has started with 16. Mr. Goswami has started on 16. Now the issue is the members of the respondent association, they want to withdraw. Not all, but 100 and something.
104
104
out of 7.
out of 700.
required it to us instead of giving to the petitioner. I was very interested.
Anyway, so the thing is that, what to do? What to do, Mr. Goswami? What to do? What to do?
The applications are not before lordship. Lordship can pass out.
So it'll be listed on the next day because it doesn't, because your application is going to be for only a few.
Yes.
So that we will allow those persons. But what will happen? Some of them are saying that we don't want to be associated. Some of
No,
them,
it is their business, we are not involved in it.
Management,
There is a association, union, trade union, they are members. They now want to, because, possibly, I don't know what they want to do. They want to accept the, settlement and get the benefit. The latest study, the last settlement which was.
I have to read, I have forgotten this case.
Your lordship should go through your lordship, detailed, dictation.
I have not seen it after because I couldn't complete dictating also. I have to rush for some meeting. Yeah. Yes. Anyway, so anyway, you give the filing number. What is the filing number? We'll list it on the next day. But in the timing, we'll hear whatever can be. To be heard.
That is one of the filing number 9162 of 2022.
9162,
2022.
9162, that's all
Yes, sir.
of 2024. File on
12.
12. 12 huh? Mr. P. Mahanta, Learned Counsel for the applicants, submits that he has filed an application whereby some of the members of the respondent number three. Respondent number 3 association are not willing to pursue the matter
But I think
and are
you have filed two applications.
So one is what?
I don't know.
and are willing to accept the settlement offered by the Oil India Limited. As the matter is, as the registry to list the same on the next day. That next day you will fix it on that. Last. Okay, hear that. Could you give me could you again go through what was the issue, the gist? Because I have totally lost.
I'll just briefly
Yeah.
indicate.
Yes, Mr. Das. We are continuing. Let him continue.
Item number 16, WPC 815070. Lord, I have already on the last occasion, your lordship got the basic facts.
No, I have completely lost track now. There
was a settlement.
Uh, there was a conciliation proceeding.
Conciliation settlement, and it gave certain terms of to the workers who are contract laborers.
Huh.
About their pay, about their allowances and all. So the respondent free union did not accept, and therefore they moved the deputy chief labor commissioner under the provisions of the Contract Labor Regulation and Abolition Act and the rules framed there. It was really first application was really under the Industrial Disputes Act. Then it was converted into a Rule 25 application under the Contract Labor Regulation Rules of 1970. 25 rule, which said, that if contract labor is doing the same job as the regularly selected candidate, they will also get the same wage. That's the provision. It's the pay parity case, basically. So that application was filed before that court, and then there was exchange of letter between the respondent free officer, the union, and the petitioner company, as well as the officer, who is respondent number 2. Finally, my lord, he decided he first entrusted the job to his own subordinate at Shillong, who could not, my lord, deal with the matter finally. And then he intimated that he will come for 3 days to Liajan and discuss the matter with them. Both union as well as the,
Who is that, the officer you mean?
yeah, the respondent number 2 officer, because he is the authority under Rule 25. Deputy Chief Labor Commission. He is respondent number 2. Accordingly, my lord, he came down to Duliajan. It was a very novel procedure he adopted for wage fixation and wage revision. He visited, the company has 36 different departments. He visited 8 departments, and then he prepared a list of 14 contract laborers and 13 regular, and wrote to the company that you arrange to bring them and I'll take their state. And that's how they all came on a particular date. The statements were recorded.
He took statements of how many workers?
14 contract laborers
14 contract laborers.
and 13 regular employees, regularly selected,
And 13?
total 36
No, 13 permanent,
permanent, who were
13 regular employees.
Yeah.
So the statements of 14 contract laborers and 13 regular employees.
And then that was done in presence of the union.
Both the sides.
President of the manager.
So they're altogether 27, that means, not
Yeah.
36.
No. Oh, no, he visited
8 out of 36
out
departments.
of 36 departments, and he prepared a chart of 14 contract laborers and
He
30
took their statement,
Yes.
basically.
And then, he delivered the impugn order, which is,
Stating that
and it's a very peculiar order. He said that his finding is that what the contract laborers are doing is not identical,
are not identical.
are not identical with the work done by the regular. At page 75. Yes, it.
Okay,
But he says that they have worked for long, acquired experience, and therefore he decided that he will give them a different structure of wage.
different structure.
Yes, that's what he did. Then what he did
He
is,
did not give them the same pay structure.
no, it's a different structure he has given. He said that he said 27,000 something, page 58. Plus he added 10,000 to the listed one.
No, 5,000, 3,000, 2,000, 5,000, 3,000, yeah,
5,000, 3,000 and
that's all.
10.
But he took that 27,000 something
Um,
from the proposal made by you or from some letter made by you or something like that.
No, no,
Explanation given by you.
no, 27,629. That was the payment
Given by you.
to regular
Yes.
and grade one. Grade one regular, because this company has, it starts with grade one up to grade 9.
Up to grade
For
9.
their regular employees. So when a employee is selected, because the regular employees are selected after advertisement in open competition. And some people are selected and they are appointed. And then they this is 58 to 59, no?
So contract employees are not, there's no selection for contract employees.
For contract employees, no selection. Because this act may not, it has two provisions. One for registration of the accepted plan, which is, I think, under section 6. Unless you have a registration, you can't employ contractors. That's the provision.
Unless you have a registration,
Under the act, they cannot employ contractors. Therefore, anyone, any industrial unit desiring to employ contract labor has to be
registered under what act?
under the contract labor regulation abolition. Because these contract workers were there from before, as your lordship know. This 70 Act regulated and
Just a minute, what is that contract?
Contract Labor Regulation and Abolition Act.
Contract labor
Regulation and Abolition Act
regulation.
and Abolition Act 1970. And the rules are called below Contract Labor Regulation and Abolition Central Rules 1971. Contract Labor within bracket Regulation and Abolition bracket close Central Rules 1971. So under section 7 of this act,
Under section 7.
7, registration of establishments are provided. Whoever wants to register themselves in order to enable them to employ contract labor, they have to apply under section 7, and that registration is given under that. Once they have that registration, they are entitled to have a contractor and
To
also
hire contractors or to hire contract laborers? To hire
contractor who will hire
engage.
them. Because the employer is the contractor. Principal employer is the person who is registered, namely Oil India Limited in this case. The contractors again are selected by the company.
So under these rules of under the Act of 1970,
Correct.
the registration of establishment are required for the purpose of hiring of contractors.
Contract labor
No, no,
as well as contractor.
but labor through the contractors. it has to be.
Yes,
Or you can hire laborers also directly.
yes, because the contractor.
So you can hire contractors or laborers
They
directly.
can give you a result or even a contract labor supply. And contractors are required to apply for a license. That's very important. Because the primary thing is the contractor, because he will have
Now,
to record.
who needs a license?
That is under section 12. Licensing of contract. First is below section 7 for the establishment to be registered. And then below section 12 licensing of contractor. Section 12 is with effect from such date, my lord has got it. Okay. With effect from such date as the appropriate government may by notification in the official gazette appoint no contractor to whom this act applies shall undertake or execute any work through contract labor except under and in accordance with a license issued in that behalf by the licensing officer. Subject to the provisions of this act, a license under subsection 1 may contain such conditions, including in particular conditions as to hours of work, fixation of wages, that is what we are concerned with, and other essential amenities in respect of contract labor, as appropriate government may deem fit to impose in accordance with the rules, if any, made under section 35, and shall be issued on payment of such fees and on deposit of such sum, if any, as security for due performance of the conditions as may be prescribed. Then 13, the license is granted. Then if your lordships also have a look at the rules, so that has some significance for this matter. Rule 21 of the Contract Labor Regulation and Abolition Act, Rule 1971. The rules start with below 17 for the purpose of registration of establishment, and then below section Rule 21, application for license. That is for the contractor. Every application by a contractor for the grant of a license shall be made online on the web portal that is specified in sub rule 1 of Rule 17 in form so and so. Every application for the grant of license shall be accompanied by uploading a copy of the certificate of the principal employer annexed to the resignation and so to the effect that the applicant has been employed by him as a contractor in relation to his establishment and that he undertakes to be bound by all the provisions of the Act and the rules made thereunder, insofar as the provisions are applicable to him as principal employer in respect of the employment of the contract labor by the Act. Because it has provided for the first time, my lord, and regulated the employment of employees as contract labor. Then below Rule 22, matters to be taken into account in granting or refusing license. And then refusing always.
No, No, what is the purpose of taking me through this?
Only thing
Okay.
is, the scheme of the act is first the registration of an establishment by which they are made enabled to have contract labor. Then the contractor who has to apply for a license. And that license will be issued to the contractor so that he can either do some work for the principal or he can supply contract labor if necessary. And then Rule 25 will the forms and terms and conditions of license. This is where the decision has been taken. So I may just place this. Rule 25, if your lordships have a look, fellows. Every license granted under subsection 1 of section 12 shall be generated electronically in Form 6 annexed to the rationalization of forms and reports under certain labor laws, Rule 2017. Every license granted under sub-rule 1 or renewed under Rule 29 shall be subject to the following conditions. Namely, the license shall be non-transferable. 2, this is important for our purpose, but I make the arguments your lordship will, I'll refer to this clause. Clause 2, number of workmen employed as contract labor in the establishment shall not on any day exceed the maximum number specified in the line. So there is a limit. He has to save as provided. In these rules, the fees paid for the grant or as the case may be for renewal of the license shall be non-refundable. The rates of wages payable to the workman by the contractor shall not be less than the rates prescribed under the Minimum Wages Act 1948 for such employment where applicable, and where the rates have been fixed by agreement, settlement or award, or by appropriate government, not less than the rate so fixed. This clause is important for us. So this is part of the license petition. Because if you don't have an agreement or a settlement, you are supposed to go by the Minimum Wages Act notification, which central government will not issue from time to time, prescribing the daily wage of different kinds of contract laborers, namely skilled, semi-skilled, unskilled.
So your case is that the contractor does not have the, the, the rates of wages payable in the license granted to him, is it?
No, the license conditions.
Yes, the license condition
I-
provides that if there are no rates of wages
Yes.
fixed in the license granted to the contractor,
Yes.
then the minimum wages act will apply. So your case is basically that since there is nothing in the license granted to him with regard to the wages payable by the contractor to his employee, to the contractor, contract laborers, so the minimum wages will apply, is it?
No, but that's not my case. Because, your lordship, there are two parts. The rates of wages payable to the workman by the contractor shall not be less than the rates prescribed under the Minimum Wages Act 1948. That is one.
Uh-huh.
For
And
such
where the rates have
employment
been
where
fixed by-
applicable, and where the rates have been fixed by agreement, settlement, or award, or by the appropriate government, not less than the rate so fixed.
Okay.
So, because if you have a settlement, say conciliation settlement, and that prescribes the rate for wages to be paid to the contract labor, then under Roman 4, the rates so fixed under the settlement will cover. And they will have to be paid accordingly. Because, my lord, the government of India keeps issuing these,
The rates.
minimum rate of wages. The payment which is provided under the settlement is more than that. And therefore, the company is paying wages which is far above the minimum rate fixed in the under this act,
And it is above the agreement.
and therefore we have a settlement. Therefore, we are to pay the higher rate fixed under the settlement. Remember, our settlement below fixes a rate which is far higher than what is provided under the minimum rate fixed by the central government under the minimum wages. We have the notification. I'll show your lordship.
No, that settlement that you have made is above the agreement that you have made, is it?
Settlement,
Is there any agreement with regard to the wages?
the
The
settlement-
initial, no, agreement with the contractor.
Settlement itself contains the wages,
No, that much I know.
which is higher than
No, the conciliation proceedings will come after you have been under your employment for some time.
correct.
But at the initial stage, when you took on the contractor or the contract laborers, there must have been an agreement as to the wages payable to them.
Normally what is happening, you have a 10-year period of settlement, as your lordship has seen in the first year. These settlements are long drawn periods because it covers lot of things and it continues. That is the pattern in this industry. Therefore, whenever the employee is inducted by a registered establishment, there can be two situations. One, there is already a settlement and rates for contract laborers. If that is so, then second part of this rule will apply and he has to be paid accordingly. If there is no such settlement or no such situation, then the minimum wages notification by the central government will apply and they have to be paid as per the terms of. Yes, so in our case, your lordship will, I'll draw your lordship's kind attention to those provisions. We have fixed rate for the contract labor through the conciliation settlement. And these rates are far above the rate prescribed by the central government under the minimum wage notification. Therefore, under this rule, since there is a settlement, the company has to pay the higher wages as fixed under the settlement, because it contemplates two situations. Since we have an agreement, we go by the, and that is what we are doing. They are paid as per the terms of the, and that is provided under Roman Code.
Then five.
Then below the 5A. In cases where the workman employed by the contractor perform the same or similar kind of work as the workman directly employed by the principal employer or establishment, the wage rates, holidays, hours of work, and other conditions of service of the workman of the contractor shall be the same as applicable to the workman directly employed by the principal employer of the establishment on the same or similar kind of work. This is the clause below under which
The pay parity has been made.
pay parity. B is, my lord, in other cases, the wage rates, holidays, hours of work, and conditions of service of workmen of the contractor shall be such as will be specified in this behalf by the Deputy Chief Labor Commissioner Central. While determining the wage rates, holidays, hours of work, and other conditions of service under Clause B, the Deputy Chief Labor Commissioner Central shall have due regard to the wage rates, holidays, hours of work, and other conditions of service obtaining in similar employment. This is the power given to this officer, Deputy Chief Labor Commissioner Central. He is the respondent number 2.
How do you differentiate between A and B?
A and B means, Milord, there are two situations. If the situation is such that the work which is done by the contract laborer
And the regular asset,
and the regular
identical.
employees are same,
Yeah.
then whatever the payment of wages is made to the regular will be paid to the
Correct.
contract.
Now, B,
B is, in other cases.
in other cases,
That means cases other than the one covered under 5A.
so what does it mean? That means supposing they don't do
Suppose there is-
similar kind of work or same kind of work, then what happens?
Then, Milord, the
Then-
Deputy Chief Labor Commissioner will determine.
But why should he determine when there is already?
No,
So-
if it is already there, he will not.
Okay.
Obviously, if there is a conciliation settlement, Milord, it will be through that. In other cases, the wage rates, holidays, hours of work, and conditions of service of the workmen of the contractor shall be such as may be specified in this behalf by the Deputy Chief Labor Commissioner Central. So, this is in other cases. In cases where the workman A, in cases where the workman employed by the contractor perform the same or similar kind of work as workmen directly employed by the principal employer of the establishment, the wage rates and all that will be same as the regular employee will get. That is the 5A. In other cases, that is clause.
What is those other cases? Example?
Milord, suppose there is no, they are not doing the same and similar work.
Okay.
Then the wage rates and other things will be fixed by the Deputy Chief Labor Commissioner. That will be another case.
No, but then,
One is, Milord,
now what about, then what about 25, 2, 4,
25,
2, 4?
2, 4. Milord, or I am, yes, yes. Your Lordship is referring to Roman 4, the rates of wages payable to the workman by the contractor shall not be less than the rates prescribed under the Minimum Wages Act for such employment where applicable, and where the rates have been fixed by agreement, settlement, or award, or by the appropriate government, not less than the rate so fixed. The
So this 6B, 5B,
5P
speaks of a situation where no rates have been fixed
fixed
by way of any agreement or settlement or otherwise,
other,
is it?
the rates of wages
I
payable
don't know, I
by
don't
the
know the difference
contractor
between-
shall not
I'm
be
not
less.
getting the difference between this 5A and B.
True. Shall,
Because that is laughing,
no,
laughing at us. Sniggering.
so far
We
5,
have to get to the bottom of it.
25, Rule 25 to Roman 4, the rates of wages payable to the workman by the contractor shall not be less than the rates prescribed under the this is the minimum prescribed. Correct. If there is nothing else. Namely, the notification issued by.
So if there's nothing else, basically it should not be less than the minimum wages.
Correct.
Then why cannot we apply 25 to 4 in this 25 to 5B?
B.
That's
In
my
other-
question.
in other cases, rates, holidays, or in other cases here will mean, Miller, in cases where the regular workman, because 5A deals with a case where the work done
By a contract laborer.
by a contract labor and the regular are state.
Correct. That much I get it.
That is 5A.
Correct.
And then the rates payable to the regular will be paid to the contract labor. B comes, which is not the case covered by 5A.
Not the case covered by 5A, can't it come within this?
In other cases, the wage rates, holidays, hours of work, and conditions of service of the workman of the contractor shall be such as may be specified in this behalf by the Deputy Chief Labor Commissioner.
No, but why is it required? My question is.
The Roman 4, 25 to Roman 4, that, my lord, is the notification issued under the minimum wages.
Not only that,
Yes. The
it
rates
says
of,
that it shall not be less than the rates of the minimum
rates
wages.
of wages payable to the workman by the contractor shall not be less. This is this provision may not fix at the bottom.
Correct.
Shall not be less than the rates prescribed by the Minimum Wages Act 1948. Because the lordship, recall, I moved the case before your lordship property industry is concerned. Normally what happens to Lord, the Minimum Wages Act provides and enable the government also to issue a notification prescribing the rate to be paid to the industrial workers of different categories. So this 25 to Roman 4 prescribes the minimum, namely the rates of wages shall not be less than what is prescribed under the minimum wages. That is right. So that provides only the minimum bottom line.
Correct.
As far as, my lord, 5A is concerned, it contemplates of a situation.
No, 5A I can understand.
Yes. And 5B, if it is not that case, that means not a case under 5A.
Correct.
Then, in other cases, the wage rates will be fixed by the statutory officer.
So my question is,
Your lordship is right. Your lordship is saying that why not 25 to Roman 4? The two different situations are dealt with by these two.
no, because you see, at the initial stage, whenever you're going to hire a contractor or a contract laborer, you are first of all going to clarify the wages payable to that person.
Correct.
You're not going to hire anyone without that.
Right.
So no one is going to be hired
Correct.
without fixing the
Correct.
wages payable.
Correct.
So when you fix a wage that is already payable, and that has been made by agreement, actually it's an agreement. Now, if it has been made by agreement,
Yes.
why is the need of 25(5)(b) when the same could come within 25(2)(4)? That is my question.
Miller, the 25 to your lordship sees
Or,
It-
I don't know, I've,
every license granted under sub-rule 1 or renewed under 29 shall be subject to the following conditions. This is a condition of the license which is specified. And what is this?
okay, this is for the contractors, only for the contractors.
Contractor's license. It's a
This
condition of
this
the
is
license.
only for the contractor.
And license is only for the contractor. Registration is for the principal employer, who is hiring a contractor and who is either giving a definite result or supplying contract labor for the different job. Therefore, 25(2) is a condition of the license. As far as 4 is concerned, that your rates cannot be less than what is provided under the minimum wages act notification. And if you have agreement, settlement or award, should not be less than that. There are two options here under 4. One is the minimum wages act, or if you have a settlement or an award concerning that, that will be the relevant thing. But so far as 5A is concerned, it deals with a slightly different situation in cases where first is minority parity rule comes in 5A. If both of them are doing and contract labor is also doing the same work as the regular workman, then the regular workman's pay will be given to them.
And if they're not doing same kind of work, then what happens?
In other cases, that is why, my lord, it is said, in other cases, while determining the wage rates, holidays and hours of work and other conditions of service under clause B above, the Deputy Chief Labour Commissioner shall have due regard to the wage rates, holidays and so and so other conditions obtaining in similar employment. As I was saying, my lord, the principle of fixation is basically the industry and the region, industry cum region. So that is reflected in this clause. There are two options given, my lord. If 5A comes into place, my lord, only in a situation where both contract labor and regular labor work do the same work, then it will be the same wages of the regular one. If that is not the situation, clause B will apply, in which case, my lord, the rates and other things will be fixed, specified by the Deputy Chief Labour Commissioner.
No, again, I'm still stuck out here. You see, the thing is that.
Yeah.
If the employment is
Yeah.
not similar, is
Yeah.
not the same,
Thing.
then you see, why is the requirement, why is the Deputy Chief Labour Commissioner required to make the wages when the wages has already been agreed upon? And if it is above the minimum wages made by the government, why should the Deputy Chief Labour Commissioner tinker with the wages?
No. If it is below the minimum wages,
If it is minimum wages, if it is above the
Under
minimum wages,
four.
uh,
then, my lord, that rate is the condition
Ah.
of the license.
correct.
Suppose that is not there, then who will decide it? 5A doesn't come because they are doing different work, let us say. But there has to be the rates of wages to be given to them. Then the 5B will come.
Okay, so you mean to say that you'll hire a contract laborer without fixing the wages, without agreeing on the wages?
Maybe that is one situation, or the labor commissioner has already done the fixation and will give him as per that. If he is not doing the same work at 5A. The period of-
I think, how much time will you take? The problem is, again, I've got a meeting at 4:40, 4:40. I've got another, so otherwise I could have heard you all.
No, it's all right, it's almost 4:40. Almost.
So I don't think you'll finish because we haven't even started.
No way,
No way.
no. There's no, I don't have to tell you lordship that. There's a lot to be said about various things. I have not come to the agreement and then the.
He has not even come to the crux of the issue.
Yes, and, no, this has huge implications for the company. Therefore, I have to,
Step by step, you're going to
step
see.
by step, I'll schedule off. I have done some part of it already. And what I propose to do is, next, I'll read out after tea, I have placed the order, issued order. If necessary, I will again refer to the.
You'll have to do that
Ah,
because I
salient
forget.
features, and then I will try to show what happens in the light of the impugned order, so far as the fixation of the wage. is concerned. That I will show from some environment, and then I will take your lordship to the judgment on 2 or 3 aspects.
How much time will you take? Totally.
I don't want your lordship to tell me.
I'm not telling you, I'm
No,
asking you to tell me.
No, I am telling your lordship this. So far, I am concerned. I always avoid that.
Okay.
Why?
No.
Because I have seen so many lawyers giving a time schedule to the learned judge as a reply, and always they can't
Finish.
stick to that.
No, why I'm saying this?
But it will take a little while. Your lordship.
No, take a little while, may take a few days or take a few hours or what?
If I get, a full day or a half a day, I'll finish the rest of it. Half a day. Half a day.
And you will, and Mr. Das, you will be taking
Maybe
around
1 hour.
1 hour.
He is very
Fast.
precise. No, he is telling everything.
He's telling everything but the main thing. He's cutting the issue. Running around the tree or
No, I don't do that.
there's the light of it.
In some matters, your lordship will have to have a little bigger sort of time for a case.
Yes.
And that.
No, that's why, no, the reason, the reason I'm asking you, the reason I'm asking you the time taken is so that, I can maybe think of certain dates.
Yes.
Instead of, we are doing it in piecemeal.
That is
We are
right.
trying to find time within the normal day.
I have a feeling
So-
that if your lordship give us a
Not one day. I cannot give so much. You'll have to try and condense your submission.
now
You'll
I
have to
have
try.
virtually given the fact on the earlier occasion. Now I am.
It's all gone. It's all I've
Uh,
forgotten.
yeah,
So you'll have to refresh and give me a gist, a short
Point
gist.
Ultimately, it will be short, within a short compact, but it will take a little while to go through that.
Okay, can we finish everything within 3 hours?
3 hours is almost a day. Yes.
Yes.
Almost a day.
Almost a day.
And then,
We can start 2 and end at 5 o'clock.
no, 10:30.
No. Morning I have got to do the normal one.
Oh, yes. Have it at 2 o'clock. 2 to 5.
Provided there's no meeting.
So many things you have to take.
I've had meeting in the afternoon. Now also I've got.
Uh,
3rd September. No, I won't be here.
Your lordship can have it.
No, 27th I've got matter. We can do it on 29th, I think.
29th of. No. Yeah. Yes. I have no problem. 28th is that case is fixed.
What?
The IA is fixed on 28th.
What?
The IA filed by learned friend.
Oh, that is nothing. That will take just 2 minutes.
No, it can come on 29th.
I can come on 29th.
That can also come on 29th.
Yeah. Twenty- Mr. B.D. Das, you're there? Is it okay? So then you keep that date locked, huh? No mentions except for, we cannot add any case on that day. 29, Thursday. 29. Okay, just one thing before that, Mr. Das. This this rule 25(5)(b) and A, what is the difference?
Difference is three possibly. In some.
No, in a very simple way, it's understood that one speaks of same kind of work, same and similar kind of work. So B speaks of the work not being similar or same. So it's
Oh.
different that way. But then besides that,
Like that, wage structure is not fixed. Supposing I am just envisaging, I have not taken instructions from the client. Entire work is being done by the contract labor.
Huh?
There is no similarity. There is no regular employee in that case. In that case, possibly,
okay. When there is no, yes, there could be, supposing there is no regular employee
regular.
doing that particular work.
You know,
Could be, I don't know.
Could be.
Could be. No, because the issue is, the
But
difficulty
as I
I'm
see-
finding,
as I see it, subject to your worship, feel the 2(4), Roman 4,
ah,
relates to a condition of life. That means
correct,
it is
correct,
an obligation of the licensee
ah,
that he has to pay minimum
Correct, correct,
wages
correct,
notification
correct,
or the agreement
Correct.
settlement
correct,
award
ah,
prices. That is prescribed as a condition of the life.
correct.
When you come to 5, it is not the condition of life. Here, two different situations are.
No, it is not only license, it talks about fixed by agreement
No,
in 25(4).
no, that is within this is the condition of the life. Let's see
ah.
how it starts.
So if the condition of a license
Yes.
allows for,
Every license granted under sub rule 1 of or renewed under 29 shall be subject to the following conditions. So it is relatable to the life. 5, there are two situations contemplated. One is where work is same by both contract labor and regular. Then regular payment will be made to the contract labor also. In other cases, that means a case which is not covered under 5A and of 4A, 4B and 5A, then deputy chief will come into it. That's how I think. Otherwise, the notification of minimum wages will always be there. So that will be a condition that you have to, as a contractor, pay them that or the settlement, if there is any. But 5A comes on a different thing.
okay, I think we'll attend the matter now.
We'll get out.
Right. Uh, heard, all the same person like last time. This is the matter on 29 at 2 p.m. Huh. 2 p.m. Hey, take that day with minimum. Then, if possible, let's get it earlier also. And then, the Mahanta case also. Just add it up. Which I gave the case in the form. I just put it there. What is that? I will take it.
And your worship will make it part of it. Then there is,
No, you see, I want at least one side to finish their thing. But I don't
No,
want to put it
because
part-
one
I-
side, beginning is part hard. Under your lordship's rule, if it is not over, it is part hard. High court rules provide for that.
No, I can be part of it. It is that I don't want the Democles not hanging over my head.
No. Don't worry
That
about that.
but-
But
Your lordship has to hear it.
I'm scared.
no. Your lordship is.
All the stalwarts are before me,
No,
and this is something new. Right.
We are.
Okay, list the matter of Siddharth Pathak.
Query.
Pathak,
Yes.
on that day we'll make it Pathak.
No.
Suppose it comes in another way.
Again, there will be problem.
Okay, list the matter of Pathak.
Part.
Huh? Okay, go ahead.
Huh?
Yes, what is
What?
this matter? That. Oh, yes. Yes.
Senior doctor in like.
Where is your senior? He's still in legs. Okay, let him take instruction. Mr. R. Chakrabarti, counsel for the respondent. What respondent? All the respondent.
Management Nolonity statement.
For the respondent has submitted, submit that the petitioner has submitted a letter dated dash to the effect that he does not wish to press the writ petition in as much as, Mr. Dasgupta said, in as much as he has been engaged in another job. Mr. A. Dasgupta, learned senior counsel for the petitioner, shall obtain instructions in this matter. What is the letter dated? What is the letter dated?
Letter dated 3/3/2016.
2000.
See, I don't have any contract with my client.
Oh.
That is the problem. Yeah, most of the cases, this type of cases will not happen. Anyway, I shall try to start.
Okay.
Sometime.
Ah.
Sometime we can.
When do you want? You tell me. But please. You see, he's not going to write a letter or send an inland letter or he's going to try to contact by mobile.
Yes.
What TV? You don't need TV for that. No one, you write letters. I don't think any of you write letters to your client. Yes, Mr. Dasgupta.
Weeks or 1 week.
1 week. 1 week.
Or one week.
This is the matter on next Wednesday. It is, but if you cannot contact him, we'll close the thing on this. 22nd, okay, leave the matter on 20. You make a translated copy of the letter. Both of them. Okay. Got it. Ah. Ah. Okay. Ah. Okay. Okay.
And then they get here. So that matter five as for
Oh my God.
And great benefit of this, like, during emergency. eviction order was set aside. Restoration was all in specific after this was filed and Indian Sugar. That was successful. And with that figure, which is dependent success as that.
So what is the message?
Because there are cases where
You need to be heard.
you need to open about.
So this is one of the cases.
What I noticed was complete.
Uh-huh.
And the vacation is set. And that gentleman became the chief minister of Tripura.
Okay.
And was paid, visa by his own government.
So is there any message in that
There may be
some cases,
for your lordship, not to be bothered about the time.
time limit? Maybe. So that we'll take a call when we hear.
I will take that. But I want to indicate it because we are talking about.
Yeah, you see the problem is nowadays and earlier times, I mean, you see the judgments of the Supreme Court also other very long judgments. Now it's become shorter, much shorter. And time constraint is very, it is there.
Long, sir.
Huh?
It's very long.
Still very long.
If you think of 1950,
Ah,
Shankar Prasad, same thing as the government. Yes, these things can take it. Here you require that one could remove. The times have
Ah.
changed. But that-
yeah, they're different aspects. What?
17, 18 matter.
What is the matter about?
The railway contract matter that was discussed on the last week about. So we come on 22nd.
Railway contract for what?
There were two repetitions filed. One was for termination, the other one is in regards to the demand notice. We recovered from the amount. There was an amount which was recovered and came to high court. We filed two repetitions. Both the repetitions are now on a hearing stage.
Acha, that 2005 matter.
No, it's 21. It was this last. Actually, this honorable court says,
Oh, that the overweight. No.
No. This honorable court says that it's not the termination of the contract. So, not please, madam, the week of a place, madam, is we are unable to manage the new tender.
Okay.
So, madam, 22nd of this month. It's nothing to do.
I don't
Second
know.
plus not, it will take my lot, it won't take too long, not 1 hour, not sir. Not a 1 hour, from this side, I will take my 20 minutes, madam. On 22nd.
My money has been taken away, so I'll have to pursue your lordship to get it back.
We
So
will-
I'll
we
take
will
at least
recover
20, 25 minutes.
I will recover them. 22nd.
I don't know.
We'll try, madam. 22nd will try.
I know you'll try. Do I have time? That's the
We
thing.
also, we're waiting up for.
It's not my fault.
Yes, sir, we understand.
You saw him, he's not finished.
No, yes, we understand.
He said he's going to take, he said that I might need 1.5 days.
Yes, not 22nd.
We have given him
No,
3 hours.
If not, madam, it's madam, no problem, 22nd.
Huh?
If it is something that.
If not this, madam, no problem, we'll take another day, 22nd.
You're putting a lot of pressure on the
No,
court.
madam,
We have fixed so many matters already.
22nd.
Anyway, okay, we'll try your luck
Yes,
if
yes,
there's time.
Try.
This is the matter 10 on the prayer of the council for the.
Extremely great. I live.
What is this? This qualification for. Huh? Because I did this.